and the respondent. Along with that, the respondent also sought for a permanent alimony of rupees 30 lakhs. Full stop. In the said proceedings, written statement have already filed by the petitioner herein. It is also relevant herein to mention that the respondent herein filed an application seeking maintenance pendant light at the rate of rupees 30,000 every month from the date of filing of the said case, along with a sum of rupees 20,000 as expenses for the said proceedings. The said application was registered and numbered as Mizze case number 37/2022. The learned court of the district judge, who's that? Pass the order.
Additional district judge.
The learned court of the additional district judge, Dibrugarh,
Yes, sir.
by an order dated 18/5/2023, after taking into account the various details, directed the petitioner herein to pay rupees 30,000 every month to the respondent as maintenance for herself and two minor children without fail. The said order was made effective from the date of filing of the case. However, the prayer of the respondent seeking a sum of rupees 20,000 as expenses of the proceedings was rejected at that stage, and the same would be considered, with an observation that the same would be considered at the time of disposal of the main divorcer. The petitioner, being aggrieved, approached this court challenging the said order dated 18/5/2023, passed in Mizze case number 37/2022. This court, after hearing the parties, by this order dated 27/6/2023, directed the petitioner herein to pay the monthly educational expenses for his two children to the tune of rupees 15,500 per month, and also a sum of rupees 15,000 being the maintenance to the respondent. It is also seen from a perusal of the said order passed by this court on 27/6/2023 that the said order was passed with due was a consent order. Paragraph number 8 of the said order, being relevant, is reproduced hereunder. Next. This court further finds it relevant to take note of that on 11/7/2023, the petitioner herein filed another application before the learned trial court, stating inter alia that there is a due of rupees 1,20,000, which the petitioner would deposit within 8 months.
But this was my application, respondent filed.
Oh. Oh no.
He was not depositing, so I filed a petition.
Allowed in page 77, annexure 9.
Oh, okay.
My lord.
The record further reveals. Now, this court further This court further finds it relevant to take note of that the respondent herein had filed an application on 11/7/2023, stating inter alia that the petitioner herein had not paid, not deposited the pendant light maintenance for 8 months, totaling to rupees 1,20,000. And as such sought for a direction upon the petitioner herein to clear the balance area on the next date, and also to regularly pay the pendant light maintenance. It further reveals that the petitioner herein submitted a petition on 19/7/2023, stating inter alia that it is a fact that he had deposited a sum of rupees 15,000 towards pendant light maintenance for the month of July before the court, in the court, as this court had directed him to pay the sum of rupees 15,000 as maintenance. It was also mentioned that the petitioner, that as far as the educational expenses are concerned, the petitioner herein has been paying the educational expenses regularly, separately. Further to that, it was mentioned that the liability to pay the maintenance amount commences from 27/6/2023 only, and not retrospectively from the date of filing of the petition, as because this court had not directed the respondent to pay the maintenance on or from the date of filing of the petition. It is therefore the contention of the petitioner herein in the said petition before the trial court that there is no balance area pendant light maintenance as claimed by the respondent in her petition dated 11/7/2023. On the basis of the same, the learned trial court, by order dated 28/7/2023, after hearing the parties, allowed the petition of the respondent but rejected the petition of the petitioner and directed the petitioner herein to clear the areas of the maintenance within the next date fixed without fail. Against the said order, the instant proceedings have been initiated. It reveals from the records of this case that this court tried to get the matter settled through mediation. In the order dated 12/10/2023, this court on account of the mediation proceedings going on, stayed the impugned order dated 2/11/2022, passed in Mirzay case number 37/2000. The state, the enforcement of the order, this court, by the order dated in view of the mediation proceedings going on, state the enforcement of the order of maintenance from the date that is the order of this court dated 2/11/2022, passed in Mirzay case number 37/2022. However, there was a categorical direction that the current maintenance shall be paid to the petitioner by the petitioner to the respondent timely on each month. Mediation failed.
Mediation failed.
Thereupon, the matter has been listed on various occasions. It has also been brought to the attention of this court that the mediation proceedings have also failed. Next. This court have duly heard Mr. A.R. Bhuiyan, the learned counsel appearing on behalf of the petitioner, and Mr. A. Batra, the learned counsel appearing on behalf of the respondent. This court have duly taken note of the order dated 18/5/2023, passed by the learned trial court in Ms. case number 37/2022, wherein it was specifically directed that the wherein the petitioner herein the petitioner herein wherein the petitioner herein was directed to pay rupees 30,000 every month to the petition respondent herein as maintenance for herself and her two minor children without fail. It was also mentioned that the said order would be made effective from the date of filing of the case. From the perusal of the said order, it is therefore clear that the direction was specific to on the aspect of maintenance of the respondent herein and her two minor children. The said order dated 18/5/2023 was put to challenge before this court in CRP IO 181/2023. This court passed the said order on the categorical the said order with the due consent of the said both parties. It is very pertinent to mention that there was no interference to the order dated 18/5/2023 insofar as there was a direction to pay the said amount from the date of filing of the case. In this regard, this court finds it very pertinent to take note of explanation 5 to section 11 of the Code of Civil Procedure 1908, which stipulates that if any relief was claimed in the plaint, which is not expressly granted by the decree, shall, for the purpose of the section, be deemed to have been refused. Under such circumstances, as there was no, as the order dated 27/6/2023 did not in any manner interfere with the said direction to pay the maintenance from the date of filing of the case by the respondent herein, the application so filed by the petitioner on 19/7/2023 before the learned trial court was completely misconceived. It was only a bogey to delay the due pay amount to which the respondent was entitled to. It is the opinion of this court that the learned trial court, by the order dated 28/7/2023, it is the opinion of this court that the learned trial court in its order dated 28/7/2023 did not commit any illegality. And as such, the question of interference with the said order does not arise. More so, in the proceedings under Article 227 of the Constitution. At this stage, the learned counsel appearing on behalf of the petitioner submits that the petitioner is willing to deposit the amount of 1,20,000. But he submits that some time may be granted. This court had put a specific query upon the learned counsel for the petitioner as within what time the said amount shall be paid. He submitted as per his instructions that the said amount would be cleared within a period of 4 months from the date of the instant order in installments. Taking into account the above, this court directs the petitioner herein to clear the arrear amount of rupees 1,20,000 on or before 15th of July 2024. This court further directs that by 15th of April 2024, the petitioner shall deposit rupees 30,000 semicolon on or before 15th of May 2024, the petitioner shall deposit another 30,000 semicolon on 15th of June 2020 on or before 15th of June 2024 shall deposit another 30,000, and the last amount has to be deposited on or before 15th of July 2024. The last amount of rupees 30,000. Failure to do so would entail consequences and a failure to do so shall be regarded as violation of an undertaking, breach of an undertaking given before this court, and consequential actions therefore would arise. This court next, before concluding, this court further makes it clear that as regard, before concluding, this court finds it pertinent to take note of the submission of Mr. A. Batra, the learned counsel appearing on behalf of the respondent, that the petitioner herein is not paying the
But he's not paying even the maintenance on time. He's paying 2,000 sometimes, then 3,000.
he's not paying the maintenance in terms with the order dated 18/5/2023, which stood modified by the order dated 27/6/2023 by this court. Liberty is given to the respondent hearing to take appropriate steps before the learned trial court for enforcement of the due order. This court further finds it relevant. Now, there is no stay to the proceeding.
My lord,
No.
payment was stayed, not the procedure.
So then,
Proceeding is going on.
Cross-examination.
with the above, the instant proceeding stands disposed.
All right.
This matter may pass over for the time being.
6 weeks.
Time being only. Leading counsel, Mr. Samaya, making submission in 8 Lord.
Huh?
Leading counsel Mr. S. Samaria is taking something like 8 lot.
What is this matter? Yes, Mr. Mehdi?
My lord, this revision is not maintainable as per law, my lord.
Oh,
Lordship,
They have
Mr.
filed it-
Samaria will oppose this.
let me dismiss it without Mr. Samaria. Okay, you argue.
Oh,
He's challenging an order
Revenue board order, my lord. Appeal
before
order.
this court. It has to be under 226.
Lordship, let me come from the section.
My
It
lord,
has
as
to be
per
under
Assam Board of
226.
Revenue Act 1962 is very much clear, my lord, sections.
How can 115 lakh?
I don't know, my lord.
Learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant proceedings and refile.
Lordship, kindly come, let him come.
No, you mean to? I'll take, now then cost of 10,000.
Must.
What is wrong with Mr. Samaria? When he is required to file, does he think that all matters are to be filed under 115? Day before yesterday also that one matter,
Yes.
which is under 227, he wants to file it under 115. Today also, a Board of Revenue order, he is now challenging it under 115. Is it a court? This is a sure case of a dismissal of AR with cost here. There is no leave here. Yes, madam, tell me.
Kindly the matter may pass over for the time.
Huh?
Kindly the matter may pass over for the time.
Why?
Senior is on.
Where are you staying? Not you, your client,
Silchar Lodge.
Silchar. And where is the tooth file? Guwahati.
Yes, sir.
What do you do? What do you do, madam?
Work in a company lodge.
Huh?
I work in a company lodge.
You are working in a company. What company?
Accenture lodge. It is on, I think, page 32, annexure
Lecture?
3 lodge. Page 32.
Hello, where is it? 830,
32 lodge.
essential. Then you're getting good salary. Why can't you go from Silchar to
Actually,
Guwahati?
Now I'm staying at Silchar and my job is presently I'm working from home lodge.
Ah, very well. Then you work from Guwahati.
So like if I'm staying with my mother and I can't leave her and travel lodge.
Then were you not married?
I am married.
Then
Oh.
if you were married, what happened? Your mother was with you.
No lodge.
Then
Actually, my father expired recently.
so is that the reason? Because your father expired, now you have to go and stay at Silchar. That is the reason of the dispute between you and your husband.
No lodge.
Then something must be there. How is it? Yes, yes, call your senior. I won't dismiss in your hands. Call your senior. I'm doing. Yes. Tell me.
May I please, your lordship?
Ah,
Your lordship, this is a transfer petition under section 24 of CPC.
oh. You are staying at Tinsukia
Yes, your lordship.
and the case is at Guwahati.
Yes, your lordship.
Why? And what are you doing?
Your lordship, because of some mental torture.
Huh?
Because of some mental torture by the husband. I have to go to Tinsukia and I'm staying in Tinsukia with my parents there.
Well, that is the usual course of events. But I'm asking you, what are you doing there in Tinsukia?
I have my home with Tinsukia, rental home.
You have your parental home, and you want to stay in with your parent, then obviously allow the divorce to be ex parte.
So because of mental torture, I went to Tinsukia. Because of torture by the husband.
Understood, but you don't want to stay with your husband.
If everything goes right, I'll be staying with my husband. But the thing is, let me read. Something, Your Lordship. I have been tortured even when I was conceived, Your Lordship.
Huh?
I have been tortured by my husband even when I was conceived.
Hmm.
And even all the ornaments, gold ornaments,
I hope. Heard an issue notice making it returnable on 10th of April 2024. The petitioner is directed to take steps upon the respondent, opposite party respondent. So responded by way of registered as well as usual. Pustak. The petitioner is further directed to take steps upon the respondent by way of dusty and file an affidavit of service during the court on or before the next date. Pustak. The petitioner herein has filed, the petitioner has filed the present application under section 24 of the Code of Civil Procedure 1908 for transfer of FC bracket civil case number 1014/2023 from the Court of the Learned Principal Judge Family Court number 1 Kamrup Metro at Guwahati to the Court of the Learned District Judge Tinsukia. It is the specific case of the petitioner that on account of mental and physical cruelty, the petitioner had to leave her matrimonial home and is presently staying with her parents at Tinsukia. It is also the case of the petitioner that the petitioner has no other source of income. And as such, it would be difficult on the part of the petitioner to approach this court, to participate in the trial before the family court, before the Learned Principal Judge Family Court number 1 Kamrup Metro at Guwahati. Taking into account the above, this court states the further proceedings of title suit of FC civil case number 1014/2023 pending before the Court of the Learned Principal Judge Family Court number 1 Kamrup Metro at Guwahati till the next stage. Yes.
Dear Lordship, the petition in the year 2003, the petitioners has filed a title suit for declaration of right title interest, recovery of possession, and for perpetual injunction. The suit was decreed in the year 2005. Hereafter, the respondent hearing filed preferred and title appeal that was dismissed. Hereafter, the decree was executed. After the decree was executed, the judgment debtor again trespassed into the land. Subsequently,
Who are
another,
you? Who are you?
I am the plaintiff petitioner,
Degree holder.
a decree holder.
Then
Then again, the title execution case was filed, but that was subsequently withdrawn. Hereafter, the decree holder preferred an application before the revenue authority for demarcation of the land boundary. Accordingly, boundary was demarcated and the pillar was given.
what is your decree for?
Decree for decree is the annexure 1 Lordship at page 27 Lordship. Relevant
Suit
party
is
is page
decreed on contest without cost. Plaintiff is entitled declaration of right title and interest. Perpetual injunction as paid for. What is the perpetual injunction you've given?
perpetual interest of claim has the annex at the time.
Then how do we know? Tell me. What is the perpetual injunction?
Perpetual injunction restraining the defendant in further construction in the suit land and in cutting trees from the suit land.
Where? Where will I get it?
Okay, let's check it.
So, restraining the defendants in further construction in the suit land.
Yes.
Now he has encroached.
Now he has, after the decree was executed, land was handed over to us. Thereafter, he again encroached. And after encroaching, he filed a writ petition before this honorable court. and this honorable court dismiss the petition. So thereafter, we file an application under section 151 of the CPC, praying for restoration of our position
How? How?
because
There is no injunction restraining him from entering. How?
in
That
the,
is not there. That is why I asked you the claim.
Yes.
That injunction is not there. That injunction is perpetual injunction as per it for means perpetual injunction restraining the defendants in further construction in the suit land and in cutting trees from the suit land. So how can you file it? Rightly. Right order. The effect of the injunction so granted earlier
Yes.
by this court during the pendency of the ceases to have effect and be since there is no standing injunction, the miscase standing regarding violation does not lie, right? Then you made them, how are you filing order 21 rule, order 39 rule 2A? Where is it?
Okay.
Guwahati.
what is it?
And you were the counsel.
Earlier, the different
Who
council,
filed this?
this application was filed by us.
My
150.
goodness. Have you ever heard of the provision of order 21 rule 34?
Yes.
What is this? We don't expect this from a people like doing civil matters. Order 39 rule 2A in a execution proceedings.
That was for, application was for.
Rightly dismiss. What to do? Withdraw. Well,
restoration.
dismiss it.
Liberty may be given.
Liberty for what?
for-
Filing suit.
Yes.
File
Yes.
suit. It's not required. Anyway. Then I'll have to touch on the merits.
Yes.
Yeah. Okay. This is an application under order 20, under section 227 of the Constitution challenging the order dated 28/2/2024. You withdraw just
Yes.
without prejudice.
Yes.
Because if I say that,
Yes.
you are finished.
Withdraw.
Mr. S. Dekar, the learned counsel appearing on behalf of the petitioner, submits that he would not like to press the instant petition. However, he submits that withdrawal of the instant petition should not prejudice the petition. Taking into account above, the instant petition stands dismissed on withdrawal. Full stop. However, it is made clear that the withdrawal of the instant petition shall not preclude the petitioner in such other remedies available. Take this. Yes, Mr. Roy, such a fat beef.
My delay of almost 12 years has been condoned by the
Oh, yes.
appellate.
I took this matter one day, no, somewhere.
Yes,
Yes. SP Roy, D. Mujumdar, both parties are here. Accordingly, list the matter on 20. Okay. Yes, what has happened? Delay of. Show me, where is the order?
order improved notary lord prefecture,
Where is the impugned order?
120. 20?
173.
This is the order, page 188.
Starts from 173, man.
Suit was decreed in the year.
Connection number 15.
It's okay.
Yes. Mr. Mazumdar, how do you support this?
The second time when he came before December court, his lordship passed the order giving liberty to the parties, to them to file objection, and we filed our rejoinder. There we have replied to whatever they have stated in their objection. But so far as the first objection is concerned, my lord, as against that, we didn't file any objection, rejoinder.
Where?
Before the court.
No. I'm asking you, we are concerned with this order, na?
This order,
Of
yes,
condoning the delay.
absolutely,
Now, this condonation of delay
my lord,
order,
my lord.
how do you support this? 2/8/2022, we are concerned. We are concerned with the order of 2/8/2022.
2022, yes.
How do you support it?
My lord,
The burden has been put on him. The other side, he has not been able to show what will the petitioners will gain by delaying the file. Hari, can that be the basis of a limitation?
that part is all right, but otherwise, my lord, this decree was of 2007. It was put to execution in 2011.
Can be done with
Can be
for
done.
another 12 years,
They-
to
they also-
2019
They
also.
also set over the decree, my lord. They didn't put to execution.
And no, 2011, the notice was duly given to his wife.
He has taken a plea that wife didn't inform him that.
And then, this is
That's
too
taken.
much.
Not
And
only
otherwise,
that,
my lord,
Lordship,
one aspect, Lord, should you kindly see. Suit was filed on the basis of I'm just one line on merit, my lord. Suit was filed on the basis of a family settlement. The trial court says that they have not been able to prove it because it was not registered and all. But again, the decree was passed on the basis of say family settlement.
Understood, it may be a case of 47. You may say, but
Other-
not a case of condoning the of
Appeal, my lord, in the appeal also, we can take the plea that this judgment is not tenable in law.
where it here. Or
No,
there.
The appeal there,
First one has to condone it.
my lord.
And that condonation which have been done has to be, I think it is a fit case for interference.
Lordship will demand, let the court consider,
Eh?
let the court, consider the
Why?
putting the burden on us.
This order is that this order has to be set aside.
That's what I'm saying. And after that, my lord,
The real grounds and reasons stated there is absolutely.
my lord, Lordship will give us an opportunity to discharge our burden before the court below
How?
for condonation of delay. Otherwise, my lord, the decree will remain, my lord. Decree, Lordship will kindly say, I'll just show one thing, my
I am
lord.
not going to, Mr. Mutunda, I am
paragraph-
not going to look into
Lordship will
those
permit me
decrees.
just two paragraphs from the
Nothing
judgment.
doing
It's an
nothing.
absolutely untenable judgment, my lord.
Whatever may be,
This will remain
whatever may be,
It's a
can
very
we say,
valuable
if
property.
these are the grounds of the, who are you?
Siblings, this is a suit between siblings. All of them are co-owners.
Lordship, before filing the title appeal, the respondent Lordship had filed an appeal before the, filed an application before the circle office for mutation of their name. And at that time, the suit was already decreed. He suppressed that fact. Ultimately, circle officer rejected the petition of the respondent. Then Board of Revenue appeal was filed. Board of Revenue also gave the finding that the appellant has suppressed the question of filing of the title suit and decretal of this title.
Where is that order?
Yes, Lord.
And the circle officer's order, where?
Yes, sir. Lordship, may I please to come to page 144 and accept.
Hmm?
Page 144. 140.
This was done on 6/5/2007.
Yes.
Then the appellants were very much present in that appeal.
Yes,
And there, where is the mention?
it is mentioned, Lordship.
About the decree,
Yes, page 146.
140?
146. Line 7 from the bottom, this entire matter is submitted before the competent civil court in TS number 50/2002, which is pending in the court of the civil judge Senior Division Number 3 in Guwahati. As the present petitioner are defendant in the suit, so the petition cannot be cancelled before the final decision of the civil court.
Then where is it that it has been mentioned that the suit has been disposed of in this case?
That is, Lordship. May come to page, Lordship, this is, it starts from page 150, Lordship. Judgment of the Assam Board of Revenue, Lordship.
Oh.
Wait,
You are showing the
Lordship,
other one, settlement of.
Page 150, enacted now. The relevant portion is, Lordship, at page 153.
This was filed on 15/9/2000 or judgment is of 2011.
11, Lord.
And when did they file this application?
This appeal was
22,
Yes,
after 11 years.
after 11. And Lordship may come to page 153. The Board of Revenue, they gave the categorical finding.
2018 the appeal was filed.
Huh?
Appeal was filed in 2018.
No, 2022 is the miss case. 14 of 2022. This is the
Appeal-
order.
Appeal was filed in 2018 along with an application.
Huh?
Its title appeal was filed on.
Then you filed the miss case after 4 years.
Yes.
Huh?
No, my appeal was filed on 22nd of March 2018 with an application for condonation of delay.
22nd of
22nd of March 2018. And the application is here before your Lordship.
and the order of the Board of Revenue is 15/9/2011.
Yes.
11. And Lordship, may please to come to page 153,
No, it's okay, I've seen it.
where the suit degree is mentioned already.
Okay. Now, this is an application under Article 227 of the Constitution. 227, 115, which one?
Lordship.
227 of the Constitution of India, challenging the order dated 2/8/2022, passed in Mizze case number 14/2022, arising out of title appeal number 10/2018. By the said impugned order, the learned First Appellate Court, that is the Court of the Additional District Judge, FTC number 3, Kamrup Metro at Guwahati, had condoned the delay of 3,883 days in preferring the title appeal number 10/2018. From the materials on record, it appears that the respondent number, that the petitioner, that the respondents herein, you are the respondents here, had filed a suit
I have,
being title suit number 50/2002 before the court
civil judge number.
of the civil judge number 1, Kamrup Metro at Guwahati, which subsequently was endorsed to the court of the civil judge number 3, Kamrup Metro at Guwahati for disposal. The said suit was decreed by the judgment and decree dated 3/7. What is the date?
Date of judgment degree
Dated
30/6/2007.
30/6/2007. whereby the said suit was partly decreed by a judgment and decree dated 30/6/2007 against the defendant numbers 1 to 11, 13 and 14. However, as regards the defendant number 12, the suit was dismissed. It was also mentioned, it was in terms with the said judgment and decree, the plaintiffs who were the respondents hearing were declared to have right, title and interest on the Schedule A, C1, C2, E, F, H, J, K, B, D-1, D-2, G and I. It was further to that, the learned trial court decreed the suit for ejectment of the defendant number 8 from the Schedule F land, defendant number 10 from the Schedule H land, defendant number 9 from the Schedule D2 land, defendant number 1 to 6 and 11 from Schedule J and K land, and defendant number 13 and 14 from the Schedule L and M respectively. It is further apparent from the records petitioner over there, he is the petitioner. Petitioner is the plaintiff. Petitioner. The petitioner filed the suit. Oh. It is further apparent from the records that the defender, who are these? Forestas and Soilendas, they are the
Defendants.
defendant numbers.
One,
Plain time.
one
Huh?
legal error of one man.
Original defendant number 1, Forrester. Lord, you can come to page 38.
Page 38. Defendant number 1 is Forrester. One of our legal errors of one man.
Further apparent from the record that the defendant number 1 in the said suit, along with the defendant number 7, had filed an application before the settlement officer for cancellation of the names of one Sachin Das and Nipen Das from the land measuring 1 bighah 4 katha 2 lechas of dag number 407 and the patta number 25, 1 bighah 3 katha 4 lechas of dag number 467, one bighah 0 katha 14 lechas of dag number 466 and the patta number 385, and 3 katha 15 lechas of dag number 196 and the annual patta annual number 5 of village Maligaon, and land measuring 7 bighas 2 katha 17 lechas of dag number 10, 25 bighas 2 katha 14 lechas of dag number 2 under KP Patta number 20 under village Maligaon, and all under Jalukbari Moja of Kamrup Metro District. The said application was, however, dismissed by the by the settlement officer by an order dated 6/5/2007. Five 2007. Against the said, an appeal was preferred before the Assam Board of Revenue, which was registered and numbered as Revenue Appeal Number 117(K/2007. The learned Assam Board of Revenue, by the judgment dated 15/9/2011, dismissed the said appeal. In doing so, the learned Assam Board of Revenue have taken into consideration that the title suit number 50/2002, which was pending in the court of the Civil Judge Senior Division number 3, Kamrup Metro at Guwahati, was decreed by judgment and decree dated 36/2007 in favor of the respondent number 1 and others in the said proceedings. The petitioner, the respondents herein, thereupon, did not take any steps. On 22nd of March 2018, the respondents herein filed title appeal number 10/2018. At that relevant point of time, there was no application filed for condoning the delay. However, in the year 2022, an application was filed for condonation of delay, which was registered and numbered as Ms. case number 14/2022.
The application is page 192.
Huh?
That application is annexed at page 192.
Huh.
And it was possibly filed on 20th of March 2018, page 200, madam.
Where?
Page 200, running page. 20th of March 2018 is the affidavit of
Then why the number it has become such?
It was not registered, it was never moved by the appellant law before the.
My
Oh,
instruction is-
was filed on 20. No, it has to be filed on 20 for both, I suppose.
Affidavit was of 20th of March 2018.
No, here it says,
Yes.
if it is filed, when it was 22nd, it was filed on 22nd.
22nd. April.
नहीं, तो इनके लिखो. This one. They had filed the title appeal in the year 2018, on 22/3/2018, along with an application for condoning the delay of 3,883 days.
Same date was filed. madam.
Huh?
Same date was filed. Page
Yeah.
192, the petition.
However-
was mentioned.
The said application for condonation of delay was subsequently registered as Ms. case number 14/2022. By the impugned order dated 2/8/2022, the learned First Appellate Court condoned the delay of 3,883 days. by observing that the petitioners were prevented by sufficient cause in preferring the appeal. It was further observed that the opposite parties, that is, the petitioners herein, have not brought anything on record as to what the respondents herein, respondents herein, would have gained by not contesting the suit and by not preferring the appeal in time. In the foregoing paragraphs of the instant order, this court had duly taken note of that the respondents herein had due knowledge about the decree passed in title suit number 50/2002, judgment and decree dated 36/2007 in title suit number 50/2022 on 15/9/2011, if not earlier, taking into account that the said aspect of the matter has been recorded, duly mentioned in the judgment and order dated judgment of the learned Assam Board of Revenue dated 15/9/2011. The explanations which have been given under no circumstances can be said to be the explanation which have been given. Now, the explanation, the learned trial court, the learned first appellate court, did not at all consider the said aspect of the matter. And without any basis of material had come to a finding that the petitioners come to a finding that the respondents herein were prevented by sufficient cause. This finding, in the opinion of this court, is being contrary to the materials on record, is a perverse finding. Further to that, the learned first appellate court, by the impugned order, opined that the opposite party, that is the petitioners herein, have not brought anything on record as to what the respondents herein would have gained by not contesting the suit. The said aspect of the matter is on the face of it misconceived notion of how an application under Section 5 of the Limitation Act is required to be considered. Under such circumstances, as the findings at the learned first appellate court had committed a glaring illegality. Which shocks the judicial conscience of this court. The impugned order dated 2/8/2022, passed in Ms. case number 14/2022, stands set aside and quashed. The consequential effect of setting aside the impugned order dated 2/8/2022 is that the title appeal number 10/2018 cannot be entertained as being barred under law. Above the instant proceeding stands disposed. IA for what?
That is, I'm not present. In the-
For my lord exercising his powers review because revision or appeal, my lord, that particular word is not incorporated there. My lord, if one judgment, my lord, kindly see that 1980, Honorable Justice K.N. Sekir's judgment, my lord, that if we will look into only two paragraphs, my lord. My lord, there is a situation that has been dealt with about revisional power. Paragraph 29 and plot 32. My lord,
This is an application under section 115 of the Code of Civil Procedure 1908, challenging a judgment and decree, a judgment and order passed by the Assam Board of Revenue under section in 10 RA bracket K oblique 2020. This court have duly taken note of section 115 of the Code of Civil Procedure 1908. And from a perusal thereof, it is seen that the power which can be exercised under the said provision is as regards any court subordinate to such high court. The Assam Board of Revenue is not a subordinate court within the meaning of section 115 of the Code of Civil Procedure. Consequently, the instant application is not maintainable, for which the same stands dismissed. Interim orders to pass stands vacant.
only one line, if lordship permits me to, my lord, that liberty may kindly be given for, my lord, avail the other whatever benefit provided under law.
That I gave him then. Your junior did not want that.
My lord, lordship only one line, otherwise, my lord.
It is subject to cost. Because this is the second time you are making the mistake.
My lord.
Yesterday 10,000, today it has to be 20,000. No, Mr. Samaria, what is this? Why, this is a simple case you should have done under 226. Why you are doing in the 115 and spoiling the time of the court?
Any lordship with any condition, but subject to lordship.
To continue. Mr. S.N. Samaria, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant application filed under section 115 of the Code of Civil Procedure 1908 against the judgment and order dated so and so in RE case number so and so passed by the learned Assam Board of Revenue. He submits that the instant application is not maintainable and the proper course of remedy would have been to assail the said judgment and order by way of a writ proceedings under Article 226 of the Constitution. Taking into account the said submission, the instant application under section 115 of the code stands dismissed on withdrawal. However, it is made clear that the dismissal of the instant application shall not, however, prejudice. It is, however, made clear that the dismissal of the instant application shall not prejudice the petitioner to avail other remedies as available under law. Taking into account that the order that the instant proceedings have been dismissed, the interim order passed earlier. Thank you.
Timing item 3.
Yes, madam.
But why is seeking transfer from Guwahati to Siddharth?
Why?
Lordship, their place of marriage is also Siddharth Lordship and last resided in Pune. Guwahati only matrimonial houses there. And
Marriage?
marriage Siddharth. For jurisdiction of divorce proceeding Lordship, first comes Lord where the marriage was celebrated.
Section 9.
19 Lordship. Every petition under this act shall be presented to the district court within the local limits of whose ordinary original civil jurisdiction the marriage was solemnized. The respondent at the time of the presentation of the petition resides, or the parties to the marriage last resided together, or in case the wife is the petitioner where she is residing on the date of presentation of the petition.
Okay. Did you notice making it returnable on 10/4/2024? The petitioner is directed to take steps upon the respondent by way of registered as well as usual within 2 days. The petitioner further is directed to take steps upon the respondent by way of the stay routed to the registry of this court and file an affidavit of service on or before the next day. The instant application under section 24 of the Code of Civil Procedure has been filed. 1908 has been filed seeking transfer of FC civil case number 1577/2023 pending before the court of the principal judge family court Kamrup Metro at Guwahati to the court of the district judge of family court at Silchar,
Yes, sir.
to the court of the principal judge family court at Silchar. The ground on which the instant application has been filed is that in terms of section 19 of the Hindu Marriage Act,
Yes, sir.
the jurisdiction lies at Silchar, taking into account the marriage took place at Silchar. The respondent resides at the respondent to the say divorce proceedings, resides at Silchar, and taking into account the said grounds, this court stays the further proceedings of FC Civil Case number 1577 of 2023, pending before the Court of the Principal Judge, number 1,
Yeah.
Family Court at Guwahati, till the next date.
May I point out one thing? She is presently residing at Silchar. She received notice at Pune. They were residing in Pune, both husband and wife. He came back from Pune and served this notice. Thereafter, she applied for work from home and she returned back to her mother.
Is that Silchar?
Yes,
So you want it at Silchar?
outlet.
Item 7.
Yes, what is this?
So here I am agreed by an order dated 29/2022, whereby my petition for recalling the order dated 7/8/2018 was rejected. The
Which
7/8
order? Page
7/8/2018 Lordship will find at page 13. Here, the survey commissioner's report submitted under order 26/10 was rejected by the.
7/8/2018 order.
Yes.
You filed in 2023.
But I am basically challenging the later part of the order, that is the order, the subsequent order dated 29/2022. The
Where is
Lordship will
that?
find at page 15.
Page
15. Here I filed a petition to recall the order passed in the year 2018, taking the ground that after the order was passed, on the same date a matter was transferred due to change in the territorial jurisdiction and after the formation of new district, that is Kitchener Charlie. So we could not locate those records, and later on we came to know about the rejection of the survey commissioner report filed under order 26/10, saying that this is not permissible as it is very clear that it would form a part of evidence and it will be looked into by the court at the time of passing the final order. But this order was passed rejecting my application, saying that no power of review is entrusted on the court.
What order was passed?
29/2022, if I may take your lordship to page 15, the operating portion your lordship will find at page 19.
Now,
That's
what
correct.
was the initial order passed?
Initial order your lordship will find at page
7/8/2018.
18. By this order, the survey commissioner.
I have heard both sides and I have given the matter dealer considering the matter. The survey commissioner has stated that due to absence of cadastral, there might be minor error in the sketches and hence, under given circumstances, the state survey commissioner cannot be accepted. I have considered the prayer of the defendants to appoint so-and-so, see so-and-so conduct the survey and propose a report. Considering the fact that preventive the so conduct the survey, they will rely on the Vandiki map and supply by the so and hence for directly the year to conduct the survey will not provide feasible result at the present. Hence, in view of the survey commissioner's report stands rejected. Yes.
So I am agree with both of the orders passed in the year 2018 and the order passed with the which is under challenge. Both the orders are under challenge. I explained in my recall petition that after the 2018 order, by the same order, the case was transferred to different charges because of formation of new districts. And
This survey commissioner report was given on what basis
we filed a petition under order 2629
earlier?
earlier.
That application was allowed,
Allowed
and on the basis of which the survey commissioner submitted a
the
report.
report. That report,
And then anybody filed an
they
objection.
filed an objection. They filed an objection,
Then-
defendant filed an objection. Saying
Then
that
the
it
court rejected the report.
rejected the survey commissioner's report. Their objection was allowed. The defendant filed an objection saying that this survey commissioner report is not.
Then what did the court do as regards the proceedings under order 2629? That order is already there. Then isn't it required for the court thereafter to appoint another survey commission? Then the order is wrong. You see, first and foremost, the law is very clear that if there is a report filed along with the evidence, it becomes a part of the evidence. Along with the material, it becomes a part of the evidence. Huh? It already becomes evidence by operation of law. It is a different thing. The court, if we see order 26 rule 10(3), or 10(2), if any objection is filed, the court may either suo motu or on an application file ask for further. Isn't that? Yes, but that becomes a part of it. You can't reject the report. The report remains all along. It will continue, which has to be decided at the time of the judgment. Isn't that the judgment in Silchar?
Yes,
municipal case?
1983 jailer.
Is there a stay?
Yes.
Stay going on?
Yes.
We will have it at 4:30. Oh, he has a problem at 4:30. We'll have it some other day then. Please the matter up to. Interim order passed earlier. We'll continue. Okay.
As per the order of the court, to recollect, they have filed
Yes,
an
yes, I
application,
remember.
will not press it. Subject to
Where is the
condition
additional
that-
affidavit?
Yes, but I think it's not on record.
Have you filed an affidavit?
They have filed.
What is your stand? And what is there?
But as we have filed a reply, we said absolutely no problem. We'll also not press, but all this, they have given undertaking here, they have to file an application there before the DRT about the surface which they have filed, they will also withdraw it. So far as
No,
the,
they have mentioned that they will.
but formally, we have no objection, man. We have also given a reply.
No, you would not be asking for any compensation for that.
That's only the problem here. My lord, under your lordship, under 18B, your lord, anyhow, your lordship has got a power. 227 overriding power. But so far as the compensation part is concerned, well, let it be decided by if they say, DRT say, no, you are not entitled to get any compensation, will not get it. But your lordship, no, the parliament, while legislating, the power has been very limited to the borrower. We don't have any power, the borrower. All the power has been vested to the bank. My lord, we have no objection. We will withdraw it. They also let them
You will withdraw
it.
what?
We will withdraw the 227 application here. We have filed against the order of the recovery officer. We said simultaneously you cannot go because surface that's hit by 35 of the doctrine of election. So now that surface your lordship has said how both can go together. Either you choose this or that. Now they have decided by an affidavit saying that they will withdraw it. only to the condition they said that we will not demand any compensation from them. Absolutely, let it be decided. We'll also withdraw the case. Let them also file an application, undertaking given.
But their affidavit is subject, is conditional,
Yeah, that's the.
subject to you not claiming
No,
anything.
but my lord, there are two appeals which have been filed by them. Two surfaces, because there were 4 application filed. Because there are 2 accounts. First account is Gabru, where now the recovery officer, again that we have come. There is SM associate, because mortgage had been extended because the price of the property was higher. So they have extended mortgage to an SM enterprise. But the mortgage is given the same property.
We'll take it about two, that affidavit is not there.
Yeah.
Affidavit not there.
We also file a reply. We
That
have
has also not come.
not come.
So should we have it on next Monday?
Yes, that's I think better.
Let the matter on Monday. On Monday or Wednesday?
Right.
On when-
Wednesday, the matter has been fixed in DRAT. So before that, if it is not inconvenient, any day,
Let the matter be, Tuesday I'm very tied up with the
Monday?
division bench. So I'll have it on Monday.
Monday.
Wednesday. No, they both the side is not
Oh,
agree. Your affidavit becomes useless with what they are saying.
Hmm.
They are saying that the legislature has categorically mentioned there is the power, if there is the illegality, they will be, the moment you withdraw that, they will immediately ask for that. Okay, if I allow your affidavit, you will withdraw, you will only go for this one. Then in that case,
I think my lord, if it is not, let it be taken on Monday, because again, that way, Monday.
this is the matter.
And if
I'm only the, this is the matter on Monday, along with the council appearing on behalf of the party has submitted that affidavit as well as an affidavit has been filed. Affidavits, pleadings, additional pleadings have been filed pursuant to orders passed by this court earlier. The said affidavits are not on record. Considering the above, this court let this matter be listed on Monday, and the registry shall be on record such a
there is interim order,
interim order past the date shall be.
I am with you. Reply of it. Right.
Yes,
Lordship. This is the application under section 24, my lord.
Huh?
Transfer a suit from Nagaon to Darang district, my lord. May I place the facts, my lord?
transferring of what suit?
Matrimonial, my lord, divorce
From?
from Nagaon district to Darang district. My main points are, my lord, the marriage between the parties, my lord, were situated in the Darang district, my lord. The permanent address, my lord, of the both parties are in Darang district, my lord, and all the witnesses, my lord, are from the Darang district. The respondent is temporarily residing in Nagaon district, my lord. And my lord, there are 3 other cases are pending, my lord, in the Darang district, under jurisdiction of CGM Darang, my lord.
Twenty-eight P.
That-
No, not possible.
That case has been already stayed by this court.
No, madam, that is not possible. We'll pick it on 22nd of April. There is a reason why. This court will pass an order. After this court passes an order, these authorities will intimate it to both the courts. Then that court has to transmit the records. You have to understand that. This is an application under section 24 of the Code of Civil Procedure 1908 for transfer of MAT bracket D case number 26/2023 pending before the court of the learned District Judge Nagaon to any competent court in the district of Gordorong. The case of the petitioner is that the petitioner and the respondent are both husband and wife. And on account of certain matrimonial feud, the petitioner left her matrimonial home and is presently residing in her paternal home. It is relevant to take note of that both the petitioner and the respondent permanent addresses are is within the district of Dorong. The respondent is temporarily only residing at Nagaon. The learned counsel appearing on behalf of the respondent does not deny to that same aspect. This court have also taken note of that there are various other litigations which have been filed at Dorong. That is Miss bracket DV case number 197/2021, as well as complaint case number 97/2023. This court have also taken note of that in terms with section 19 of the Hindu Marriage Act 1955, the suit ought to have been filed, the the divorce proceedings ought to have been filed at Dorong. Under such circumstances, this court transfers the MET D case number 26/2023 to the court of the district learned district judge Nagaon to the court of the learned district judge Dorong. We will transfer it. Yeah. You have not filed your written statement?
Not.
Taking into account both the parties are duly represented and the petitioner herein have not yet filed a written statement, the petitioner shall file her written statement on the next date fixed in the court of the district judge Dorong. This court fixes the matter for appearance of both the parties in the district before the district court at Dorong on 22/4/2020.
They may be affected.
In time orders, if any stands.
High level.
Last week ni na koi ase no. Kita tolo side paragraph.
Apply.
22. Yes, what is this?
Lordship, plaintiff's evidences were closed, Lordship.
Huh?
The matter was fixed for argument, Lordship, at stage in this court. Notice was issued, proceeding was staged, Lordship.
Which order we are challenging?
Lordship. 19/12/2022,
Where is that? Impugn order?
yes. Lordship, page 30. All the order sheet I have already enclosed for today. Started from ADR, annexure 3, page 20. If you order is at page 30.
You are challenging 19/12/2022. Side submitted their list of witnesses. Let the same be kept on record. Learned counsel for the plaintiff submitted list of witnesses and sought for adjournment. It appears that today is the last chance for the plaintiff's evidence. But today also the plaintiff, hence the prayer is rejected and the plaintiff evidence is hereby closed. If there is a counterclaim,
No, Lord. On 7-2, Lordship, they refused to adduce any evidence, so the matter was fixed for argument.
and the court has fixed for argument.
Yes,
My
Lordship.
goodness.
Then we have filed 151 application, Lordship, on 3/4/2020.
Then
31. That was also rejected. For allowing to submit evidence in the suit by recalling the order dated 1912. That was also rejected.
what is your, or let us see your petition on 19-2.
19-2, Lordship.
The aforesaid case is fixed today for a plaintiff witnesses due to his illness could not attend this court
Lordship.
due today and therefore another date is fixed. How many witnesses are there?
Lordship, I have submitted 6 weeks. Page 35.
All were ill.
So, Lordship, plaintiff, Ahmaduddin was dead, Lordship.
Then?
No, Lordship, that list of witness was submitted on 1912.
No, we are not concerned. So only one witness, no
This is
further.
the person who was taking.
There is no further witness. Okay, one witness against each witness. How much? 5,000.
Not the list of witness.
Huh? Yeah.
There were 3 last time. I have barely barely the moment. 3 last time. Right? That 8, 27 last time. Then again my 7, 9 last. Then
And
again my
5/4/2022 plaintiff evidence. 13/5/2022 plaintiff evidence. 22/6/2022 plaintiff evidence. 26/7/2022 plaintiff evidence.
last time.
7/9/2022 plaintiff evidence.
Last time.
16/11/2022 last chance.
Again last.
Lordship, on page 28, your Lordship will say that 22/6 is due to flood.
Huh?
Due to flood.
Which one?
Page 28, order dated 22/6/2022.
Yes. It's okay, but so many other
Four
chances are there.
adjournments, Lordship, I have counted 4,
I
5
thought, I
adjournments.
thought there are many-
No. First, the court should have dismissed the suit. On the basis of there being no evidence, yeah.
Lordship, the petitioner, main plaintiff, Lordship.
You do the argument. That court may very well do the something. This court is not going to touch anything. I'm on the other hand going to say that what is this type of thing going on? When the plaintiff has no evidence, defendant has no evidence, and the suit is proceeding for arguments. Doesn't the court knows the basic aspect that you couldn't have done that?
Medical document of the, I thought, well, Singapore country. Coming,
Kindly consider,
coming by
Lordship,
the-
plaintiff
after-
suit, Lordship.
after 10 months.
They all are brother and sister, Lordship.
Medical document is of Singapore country, 2024.
Both the parties are from the same
Right, the
legal
last
layer,
bill.
Lordship. There was an amicable partition. And thereafter, Lordship, dispute arises, so the suit was filed.
I thought also, it's run by the clerk. Self, by the entire, by the clerk. Nobody has done so. For yes,
2022 matter.
all evidence are filed with the clerk.
No, madam. One has to be
2022
strict.
matter, Lordship.
What is it?
No, one and one, any pages, all are evidence. Not filed, not by the, no party, evidence cannot file, don't by clerk.
Let us see that one. 19-2 is
1912,
there.
Lordship.
Translated here. 1912. That is also clerk.
Party is not in the court, never would be. And medical document is of December 2024.
Lordship, Claim was signed by Ahmaduddin, affidavit page 18, Lordship.
No, madam. I'm dismissing it.
Only one
If I
witness.
dismiss it, no. If I dismiss it, I will say, what is the trial court going to do, doing with all this type of suits, spoiling the judicial time? When there is no evidence, how can the plaintiff, pleading is not evidence. Doesn't the court know the fundamental aspect? Without there being a counterclaim, the court should have dismissed the suit right away.
Already list of witness submitted, Lordship.
No,
Kindly
not
consider,
necessary.
Lordship, by imposing some cost for
Therefore, this is an application under Article 227 of the Constitution, challenging the orders dated 19/12/2022, passed in title suit number 176/2019, challenging the orders dated 19/12/2022, 7/2/2023, as well as 3/4/2023, passed in title suit number 176/2019.
to kindly consider 151.
No,
petition
madam,
was
no,
Also
nothing
filed by
will-
the Amaduddin, Lordship.
Absolutely no, this is
He
not a
himself
case.
swear
Sorry,
the affidavit, Lord.
no, nothing.
It is
One has
not
to
a
be
case
strict.
that
No,
al-
no, no.
always the clerk has
Full stop.
separate, Lord.
From the perusal of the materials on record, more particularly the order sheet of title suit number 176/2019. No, anyway, from the perusal of the materials on record, it seemed that the plaintiffs have filed a suit seeking declaration that the plaintiffs are Ismaili owners of Schedule A land by way of an amicable distribution of the defendant number 3, as well as for permanent injunction. The defendants filed a written statement denying the case of the plaintiffs and sought for dismissal of the suit with compensation. From the record, it reveals that on 5/4/2022, issues were framed and the case was fixed on 13/5/2022 for plaintiff's evidence. The plaintiff sought for time to submit their evidence on 13/5/2022, 22/6/2022, 26/7/2022, 7/9/2022, 16/11/2022, 19/12/2022. The learned trial court, taking into account that 3 last chances were granted. 1, 2, 3. 3 last chances were granted. Closed the evidence of the plaintiff and fixed the case on 7/2/2023 for defendant evidence. On 7/2/2023, the defendant submitted that they would not adduce any evidence, for which the matter was fixed on 15/3/2023 for arguments. On 15/3/2023, the plaintiff sought for again adjournment. Thereupon, on 3/4/2023, an application was filed for recalling of the order dated 19/12/2022 on the ground of illness of the plaintiff of one witness. The learned trial court rejected the said application and fixed for argument of judgment. And under such circumstances, the matter has come before this court by way of the instant proceedings. This court have duly taken note of the provisions of Order 17, Rule 1 of the Code, which categorically stipulates that no adjournment shall be granted for more than 3 times to a party during the hearing of the suits. This court further finds it relevant to also take note of that it is well settled that the hearing of the suit shall start from when? After framing of the issues. In the instant case, not only 3 times, the plaintiffs were given 3 last chances, then also did not file their evidence. The order dated 19/12/2022 under such circumstances cannot be said to be illegal or suffering from any material irregularity. However, this court finds it very pertinent to observe that it is a well-settled principle of law that pleadings are not evidence. Under such circumstances, when there was no counterclaim filed by the defendant, the learned trial court ought not to have fixed the matter for defendant's evidence, as there was no evidence on the part of the plaintiffs. The learned trial court ought to have dismissed the suit then and there. Under such circumstances, this court have also taken note of the order dated 3/4/2023, which also shows that the learned trial court was justified in rejecting the said application, seeking further time for submission of the plaintiff evidence. Thereby asking for recalling of the order dated 19/12/2022. Under such circumstances, this court finds no ground to interfere with the impugned orders. This court further vacates the order of stay dated 3/5/2023 and directs the parties to appear before the learned trial court on 8/4/2024. The learned trial court shall duly take note of the above observations while disposing of the suit.
Yep.
एक घुराई बेटे
Please resolve it.
which order?
The order of amendment, my lord. Order allowing amendment is, my lord, impugned in the present proceedings, my lord. The order is start from, my lord, is 91. my lord.
What is the stage?
My lord, stage is, my lord, the issues have been framed. We have taken step under the SBPS for production of the document, my lord. I was dependent in the suit.
So why should we interfere?
My lord, it is a stage where, my lord, the issues have already been framed, the trial has started. Now, once the trial has started, my lord, if an amendment petition, then it should satisfy, my lord, that what
Why?
were the due diligence that were done by the plaintiff while instituting the suit, which prevented him from filing all the relevant pleadings. In this case, my lord, the facts are bit such, my lord, what has happened. My lord, my client,
Where is the application
my lord,
for MP amendment?
our objection is also there, my lord.
No, their application.
Yes, my lord. 73, my lord. It starts from page 7.
What is he asking?
My lord, 2 paragraphs they want to
Doesn't that
incorporate.
at the time of execution of the pension number 2, but so these two,
My lord, yes.
A is third line of the plaint after the word defendant number 1 may be corrected C, third line. First line of the plaint has to enter the word defendant may be corrected as plaintiff. Yes, what is wrong?
My lord, now the grounds which they are taking, my lord, in paragraph 6, my lord, they want to bring it.
Mr. G. Rahul, only question out here is the court had only imposed the cost should have been 25 or not less than 23,500. That should have been the cost. That is the only thing I can interpret. Instead of 2,000, 23,500. Pay that cost. That is the only. What ground? Why other grounds should be looked into? Once the trial has started, is that statement necessary for the proper adjudication of the truth? More particularly at C. 1 and 2 is okay, A and B okay. These are minor things. What is C? You didn't know. This is a further allegation being made for purpose of proving the fraud. Isn't it? That person was very much not there here. He was in Bombay or something. Isn't that the case? Didn't you know at that point of time? So, so come to the judgment in mentioned about this Union of India versus Major Mohan Madan Lal that has been mentioned in paragraph number 9. The judgment. Huh? Paragraph. Turi Animal. And let's see the next line. After that, just before paragraph 13. It is not an authority for the proposition that the trial would not be deemed to have commenced on the date of first hearing. In that case, as noticed herein above, the documents were yet to be filed and therefore it was held that the trial did not commence. Now tell me then, you are a lawyer in the civil court, tell me, what is order 13 rule 1? Tell me. Order 13 rule 1 says that on the first day, after the issues, before the issues of the documents are required to be submitted in original. Okay. This will be marked. Then the issue will be. Isn't it? So here it says submission of the documents. Then even before the issue. So what? It is a different thing. We are not before that. I am not interfering with that order. The cost has to go. They'll have to file an additional written statement. You have to pay that. It's because of that. Then only it becomes realistic. You one fine morning, you wake up and say that, oh, this paragraph I forgot. Who is going to file the additional written statement? You pay the cost for that. Whatever Mr. G. Rahul charges, you give a bill. Pay that. 23,500. The prayer is gone. Can't happen like this. You can't have this 2,000 cost nowadays. 2,000 cost is too less now. I would have understood in other districts. Guwahati is not like that. This is in Guwahati. My goodness. That too in civil judge too. 2,000 is too many. I won't interfere. But cost has to go. You have to deposit the cost of. Okay, let's make it 10,000, 11,000. 10,000 and 1,000 more. 11,000. This is an application under section 2 to article 2 to 7 of the Constitution challenging the order dated 12/7/2023 passed in Mize case number 423/2022. A perusal of the impugned order dated 12/11/2023 reveals that an application was filed by the plaintiff seeking amendment of the plaint to the extent as mentioned in paragraph number 2 of the said application. The respondents filed their written statement and filed their written objections. Objecting to the amendment of the plaint. The learned court below, the learned trial court, by the order dated 12/7/2023, allowed the said amendment with a cost of rupees 2,000 to be paid to the defendants. Being agreed, the instant proceedings have been initiated. This court have duly taken note of the stage at which the said amendment application was filed. That is, at the stage after framing of the issues and at the time when steps were being taken in accordance with Order 16 of the Code. This court is of the opinion, this court, having perused the impugned order, is of the opinion that the learned trial court did not commit any illegality, had not committed any jurisdictional error or any illegality in permitting the amendment. Inasmuch as a perusal of the said amendment reveals that the same are required for an effective adjudication of the suit. This court, however, finds it very pertinent to observe that with the allowing of the amendment, the suit goes back to is relegated back to the stage of pleadings. Thereby, the defendant now has to again file an additional pleadings. And further, go ahead with the ordeal of framing fresh issue, further ordeal, and further proceed from that stage. Under such circumstances, the cost which have been imposed of 2,000, in the opinion of this court, is not reasonable. And this court, therefore, this court is of the opinion that the cost which should have been imposed should have been at least realistic, for which the cost for allowing the amendment application is increased to rupees 11,000. You have filed the amended plaint? Huh? Okay. The plaintiff is directed to file the amended plaint. This court, further taking into account the above, vacates the order dated interim order there. Where is that? Vacates the order dated 2/8/2023. and thereby directs the parties herein to appear before the trial court on today is 15, na? Today is 15. On 28th, on 28/3/2024, on which date the learned the plaintiff shall file the amended plaint failing which consequences in terms with order 6 rule 18 shall follow. Further to that, the plaintiff shall also deposit the cost of rupees 11,000 so imposed at the time of filing the amended plaint, which shall be a condition precedent for acceptance of the amended plaint. This court further observes that this court further directs that the defendant shall be at liberty to file an application before the trial court and for release of the said amount, and the trial court shall pass appropriate orders thereupon.
Right. Wait, but that matter, my lord, of Numaligarh refinery, my lord, where we had come against the non-vacation of the interim order, lordship had directed.
Oh, this one.
Matter be heard, my
Okay, where
the
its
ma-
hearing is going on.
hearing is concluded, my lord. It has been fixed for filing of written arguments next Friday. Can it be taken up thereafter, my lord? Something remains, my lord.
Next Friday, na?
Next Friday.
So we let us have it on 27th.
28th, my lord, 27th, I have some capital.
No, I will just pass one order on 27th. Taking into account, this court will only request the district judge to dispose of the AR. I think
27th.
27, 28, no. Then I think the matter then finish off.
Yes.
And the hearing has been completed, then nothing remains here. Submit your written submission, whatever may be, whatever points they resigned, you say that court knows how to tackle it. So they will do it. So don't come up with all these issues. He is going to today finish it off.
Yes.
Complete it.
Complete.
So then it will be only fixed for written arguments.
Written out.
Okay. I'm not concerned with all of that. Hearing is completed and the written arguments are to be
22nd.
submitted on 22nd. Has he fixed for judgment?
No.
Okay. It has been submitted at the bar by Mr. N. Decker, the learned counsel appearing on behalf of the petitioner, and Miss N. Bedi, the learned counsel appearing on behalf of the respondent, that the hearing in respect to arbitration case number 34/2020 before the
District judge.
Miss arbitration case,
Miss Ar-
before the learned district judge, Kamrup Metro at Guwahati, had been completed. And the learned district judge had fixed the matter on 22/3/2024 for submission of the written arguments. So taking into account the above, let this matter be fixed. Let the instant petition and the proceedings be again listed on 27/3/2024 for further update.
Into the last order, Lordship, NHAI have filed their affidavit, Lordship.
Why is this matter before me? No, why this matter is before me?
Lordship,
I'm not taking up this bench.
Lordship, this matter was initially for your Lordship was taking this file.
Specifically assigned.
Lordship. The
Why?
Lordship had asked for the record, then then Lordship had asked for the records of the case, your Lordship, from NHAI, Lordship.
Ah,
And on a subsequent date, when the matter came up before another court, it was observed that because the records were being asked by this particular court, Lordship, that the matter may come up before your Lordship.
is it?
Yes, Lord.
Oh, this one. Oh, this matter. I remember. I issued the motion. Nah?
Lordship, Lordship.
Your basic submission was the 3D was not there.
Lord.
Nothing. Quick disposal of a matter. Where's the Assamese one? LA case number 1 of 2023. Oh no, this is for cruise pride. This is for National Highway, na?
That's right.
National Highway, where? Which page? What is National Highway thing comes so much? National Highway, I think now spends half of their money on advertisement. Huh?
Some people not sure of it. Sent
this
it
one?
to page 13, your
Page?
13, Lord.
one?
Lord. Sent it. Continue.
13. Yes. Where?
Page 10.
Where is that? Page 11. Continue from page 11. Yeah. Where does this start from? Oh, yeah. Statement of the list of 17 unclaimed vehicles? No?
Lordship will come to the newspaper dated 10th of March 2023.
No.
2nd of
This
March,
one at page 10 continued from 22-3.
Lordship. The previous newspaper. Lordship.
You published 2 dates.
Lordship will come to page 6.
Page 13.
Page 6. Page number 6, your Lordship.
Yeah. 21 1. Yeah. Under 3A, hereinafter referred to the central government after being satisfied that the public purpose is denied. So your land is here. So nothing you mean. Okay. I should have spoiled so much of time now going through all this. This court, by an order dated 1/9/2023, had issued notice in the instant proceeding, taking into account the limited grievance of the petitioner. That while issuing the notification dated 29/5/2023 under Section 3D of the National Highway Act 1956, the respondents did not comply with Section 3A of the National Highways Act 1956, and more particularly to subsection 3 of Section 3A. Pursuant thereto, the respondents NHIDC had filed an affidavit in opposition. And placing on record the gazette notifications, gazetted notification, as well as gazette notification. Placing on record. Placing on record the notifications issued under section 3A of the National Highways Act 1956. Taking into account that the said notifications did not and taking into account that the enclosures to the said affidavit were not clear, this court, by order dated 16/2/2024, directed that the newspaper advertisements be brought on record by filing an affidavit. In pursuance thereto, on 12/3/2024, an affidavit has been filed wherein the said notifications have been brought on record. Further to that, the learned counsel appearing on behalf of the NHIDCL have also produced the original newspapers which this court have duly perused. Taking into account the above, in the opinion of this court, the allegation of infraction to subsection 3 of section 3A of the National Highway Act 1956 by the petitioner is totally misconceived, for which the instant petition stands dismissed. Good. That was it.
Only for today, your lord.
leave application is for 14 and 15.
Hmm?
His leave application reflected in the for 14 and 15.
23, why?
Lordship,
We'll see. Well, the matter is 14, don't worry, may not. 14
Your Lordship,
this is the matter after 6 weeks at the request of the learned counsel for the appellant.
Your Lordship, she will be here. I have to apply here.
You see?
As for the last order of the honorable court, 14, 12, 13, we have to take step upon the legal heirs of response number 2 and 4 of it. And if you look at the official dated 11 March 2020, 11 March 2024. Services upon the respondent legal heirs of the response 2 and 4 have been completed, except response 2 1 not found. Respondent does not live in Surabari village. Except that respondent 2 1, all the respondents have service of all the respondents have already been completed. Two one is the wife of Fazal Ali. Respondent number 2, who is the one of the son of the original Pattada. Legal 2 1. Saharana Khatun, wife of Fazal Ali. That is respondent number 2.
Why are the brothers made parties out here?
The appellant is one of the daughter of the original Pattada. So
Understood. Why the brothers are made parties? After the death of Fazal Ali, why his brothers are made parties? Substituted, why?
he has six, they have 6 brothers and 2 daughters.
Hmm?
They have six brothers and 2 daughters, 2 daughters of the original Pattada. And the plaintiff, the present appellant filed the suit for declaration of the title, partition, and
And the respondents have not appeared.
has appeared with it. As per the order dated 23rd
Their
January,
names have been shown in the cause list,
my name is not.
your respondent's name.
Respondent Lordship, if you will also kindly see the order dated 23rd January 2012.
Ano yung cause list ko? Wakalat naman ko.
It is reflected in the order Lordship, 23rd January 2012. As all the respondents have been represented, the case has been directed to be listed in part 2 hearing list in due course.
Wakalat naman ko. Yeah. This wakalatnama is of 2007 of the respondent. Thereafter, there is no 3rd of January 2019. Rishikesh Das. Itti dekha. No, the respondents are not represented because 2 and 4 had died.
Yes.
Okay. The
But
suit was filed in the year 2000, the appeal was filed in 2007.
And also if the finalist did the order that is 23rd
Arre.
January, 23rd
That
January.
is a different thing. There are two wakalatnamas.
Yes.
There are two wakalatnamas. None of it has appeared on behalf of them. After the death of these persons, none has appeared. It all happens because of the delay in disposal here.
But in the order that is 23rd January, it was reflected that all as the respondents have represented, appeal may be listed for hearing in due course in part to hearing. Order dated
This
20
aspect was not taken note of, na?
Yes.
See, there are two wakalatnamas of the respondent. One is of both are executed in the year 2007. Now, of these respondents have died. Once it is dead, the lawyer becomes useless. Now, what to do? As regards the respondent number 2-1, she does not stay out there.
it does not say in Pura village.
Huh?
Puravari village. He does not live in Puravari village.
But daughter has received. So none has appeared.
Other legal have accepted notice.
Okay. Taking into account that the estate of the deceased, defendant number 2, is duly represented by service of notice upon the respondent number 2 to 11. This court deems the service upon the respondents to be complete and accordingly lists the matter for hearing on 2nd of April 2024.
Here the appellant died, Your Honor, in the year 2023, in fact, maybe in March, April. So I was informed about that, and I have communicated with the surviving wife and his daughter, and they asked me to send the Ukalatnama and all. I have sent it out, but then since then they have not responded. No communication from that. About,
This court have duly taken note of
yes, sir.
that on 8/5/2023, it was informed to this court that the appellant had expired. Thereupon, a period of 90 days have elapsed. Under such circumstances, the instant appeal stands abated and stands closed. And accordingly stands
Obliged.
LCR, the registry shall return the LCR. You are appearing for? No, appellant number 1 had expired. It reveals from the records that the appellant number 1 had expired, as was informed by the learned counsel for the appellant on 31/2024. The appellant number 1, as per the memo of appeal, was the mother of the other appellants. As such, the estate of the appellant number 1 is duly represented, for which there is no necessity for filing any further application for substitution. Accordingly, the instant appeal be placed for hearing by the registry in the month of April 2024. You are? You are for the respondent. You died. Monoranjan Banik has died. Has he been substituted? Huh? Petition filed. When? I এখন করছি। এবং মিস্টেক হয়েছে তো। একটু সিআরপি হয়। Give me the mistake. Huh? What review? Miss case in review petition. There's a review file. Where's the review? Any review? Huh? Review petition. What is this review talk for? The total moment died. How much is the delay? What is this? Why they are challenging this MFA? Let me see CRP. What is this CRP business? Challenging what out? No, forget it. Challenging the legality and validity of the order dated 10/1 and the notice dated passed by the civil judge to ensure directing payment of 14% interest from the date of business, which did not fix any rate of interest and overlooking the fact of tendering the critical amount by the We'll do one thing. ACB. I think ACB, as of now, there is no ACB. They need to substitute that also. There is no ACB. ACB has merged. Review petition is not necessary. Review is, in fact, the review shouldn't have been filed at all. Not necessary. These petitions out there. But the fact that as of now, you don't have Assam State Electricity Board. It has merged with APTCL. So they have to take action. We'll do one thing. None appears on behalf of the applicants on call. You are nobody. How can you appear for a dead person? Now, none appears on behalf of the applicants on call. It seems that the applicant is not interested in the instant application, for which the application stands dismissed on non-prosecution. I won't put your name as of now. You are not there. On me.
May please, Your Lordship. As per office note dated my lord 13/3/2024, services completed against all the legal years of Respondent Mapropa.
From a perusal of the office note dated 13/3/2024, it reveals that the service upon the substituted respondent numbers 1.1 to 1.5 have been duly served. Consequently, as the service is complete, leaves the matter for admission.
My lord. But,
Huh?
names of my lord, respondent number 6 and 7
maybe struck off.
Understood?
Otherwise, ready, my friend. Okay.
Listed for admission,
Admit.
admission. On first of April.
Okay.
Yes,
Lordship, the dispute,
yes, sir.
there was a good dispute between the brothers.
Huh?
Dispute has been resolved between the parties. And in the meantime, the respondent has also expired. So we are,
Withdraw.
this case is filed for condemnation of delay. So the appeal was dismissed for default in 2000.
Withdraw. Mr. S.C. Kyle, the learned counsel appearing on behalf of the, it will be in the miss case
Yes,
for
appeal,
condonation of delay for what?
Lordship, the suit was, appeal was dismissed for default on 30/11/2015.
Okay, you want to rest for restoration,
Yes, Lordship, now it is.
delay of 201
Yes.
days. We do one thing, we restore the appeal and dismiss the stay on withdrawal.
Lord.
Because I can like. Petition kami bitin na pa man upa order.
The order has been annexed with SKS 917.
Application is 3 pages, orders are 14 pages. IA 917/2016 and Miss Case 208/2016. Both the applications are taken up together for disposal. IA 917/2016 is an application under Section 5 for condoning the delay of 201 days in preparing. For preparing what?
For restoration of condemnation of delay for preparing the application for.
Huh?
Lordship,
Okay, for preparing the application for condonation of, for preparing the application for restoration of the appeal, which was dismissed for default. By an order dated 30/11/2015. This court have duly taken note of the grounds mentioned in the said application and is of the opinion that the same constitutes a sufficient cause for condoning the delay. Accordingly, the delay of 201 days is preparing the application for restoration of the appeal. It's condoned. The miss case number 208/2016 is an application for restoration filed under Order 41, Rule 19. The grounds and reasons stated therein, in the opinion of the court, is sufficient for restoring the appeal. RFA or RSA? RFA.
RFL.
RFA. Appeal. Being RFA number 87/2004. Accordingly, the instant application stands allowed. Mr. S.C. Kyle, the learned counsel appearing on behalf of the appellant. Submits that the matter have been amicably resolved, and as such, the appellant would not like to prepare the instant appeal, further continue with the instant appeal. So taking into account the above, the instant appeal stands dismissed on withdrawal. LCR has come. এইটো ৰেষ্টৰ কৰিলো, ৰেষ্টৰ কৰি আকৌ dismiss
Much.
taking into account the office order dated 7/2/2024. The service upon the respondent, taking into account the office order dated 7/2/2024, it reveals that the service upon the respondent numbers 1, 2, 4, and 5 is duly complete. The office note further reveals that the respondent number 3 had expired. Miss, what's your name?
Hero.
So appearing on behalf of the applicant submits that some time may be given for taking appropriate steps. List the matter after 4 weeks. The record reveals that the applicant have not appeared before this court on P1/2024. Further to that, the office note also reveals that the steps by usual process have also not been received. It seems, therefore, that the applicant is not interested, for which the instant application, they got IA Civil 3432/2019, stands dismissed for non-prosecution. Consequently, the restoration application being barred by limitation, restoration application being IAC number 3434/2019 being barred by limitation, stands had become barred by limitation, and according this application also stands dismissed.
Five.
Lordship, as per the office note, service report upon the sole respondent is await.
Delay.
Delay of 5 days, Lord.
Delay of?
5 days.
Okay, what is the order passed? What are you challenging? Let us see. Guardianship.
Yes, Lord. Para 10, lot, page number.
Huh?
Para 10, page number 8.
Page number
8.
what is that? Guardianship is a Srimati, appellant is Srimati Suman Kumari. And guardianship of what?
Guardianship was filed by the grandfather of the children, Lordship, and Suman Kumari is the mother,
And the guardianship was dismissed.
Lordship.
Then how are you agree? Ms. J case was filed by whom? Ms. case was filed by, in view of the above, the petition filed by the petitioner. Who is the petitioner? This is the order. Yes. Filed by the petitioners is dismissed, however, leave the bearing the year the case is disposed. Now we have to lecture this. Who is the petitioner? Petitioner is Sri Rangoti Singh.
Ramgoti Singh, Lordship.
Then
He is the grandfather.
praying for granting guardianship and pass an order to hand over the minor so to the petition. Now this petition has been dismissed.
Lordship,
Why are you agree?
there's an interim order passed in the judgment, Lordship.
Which order you are challenging then? 14/8/2018. 14/8/2018, the mistake has been dismissed. The mistake case has been dismissed. What order? One discussion reasons. Paper filing. You are the husband. You are appearing for the mother,
Mother, Lordship.
and father is there.
Expired.
And grandfather is who?
Ramgoti Singh, Lordship. He filed the guardianship.
And are these people now minor? This order was passed in 2018. What was the age of the child at that point of time?
Elder son is now, Lordship, 17 years.
How do you know? Oh, the father is dead.
Lordship.
So it is with the mother. So there is a direction out there. However, to what relief? However, the petitioners are allowed to have full access to the children, namely Raj Singh as earlier order dated on so. They also directed to cooperate with the petitioner in this regard. Moreover, the petitioner has also been provided have visitation. So what is wrong? Grandfather wouldn't like to meet the child, the grandson. Nothing is wrong. Unnecessary. You have the guardianship, everything is there. Then only the grandfather would like to meet them. And all along from 2018, she has been meeting. We are 6 years down the line, and now you want to fight? You condone the delay, you withdraw the appeal. Okay, unnecessary, don't make all these things. Now, grandfather. Oh. This is an application filed under section 5 of the Limitation Act. 3873 of 2019. This is an application under section 5 of the Limitation Act 1963 for condonation of the delay of 5 days in preparing the accompanying appeal. This court have duly perused the materials on record and is of the opinion that the grounds assigned therein are sufficient for condoning the delay. Accordingly, the delay stands condoned. Honorable appeal. Delay boleh tu order tat. Tu order tin. The learned counsel appearing on behalf of the applicant submit that taking into account that by judgment dated 14/8/2018 passed in Mize case number 60
Lordship.
60/2016, the said application filed by the grandfather of the children, our grandfather of the minor, that the minors Sri Raj Singh and Sri Rishabh Singh was rejected, filed by the petitioner. The learned counsel appearing on behalf of the applicant submits that since by judgment dated 14/8/2018, the Mize case number 60/2016, the application filed by the grandfather of Sri Raj Singh and Sri Rishabh Singh for their guardianship was rejected, and a passage of 6 years thereafter have passed almost 6 years have passed through. The applicant hearing would not like to further proceed with the instant proceedings. Taking into account the above, the instant application stands closed on withdrawal. You are paying for? Where is the applicant? Why haven't you filed your objection? You filed the objection. Delay of? None has appeared on behalf of the applicant on call. So Mr. T.J. Soike appears on behalf of the respondent. He further submits that he has filed objection against the condonation of the delay application. So taking into account and for the end of justice, the matter stands adjourned to be listed on 3rd of April 2024. It is made clear that if the applicant is not represented on the next date, the instant application shall stand and this court shall pass appropriate orders.
Petition for condonation of delay, my lord.
How much?
800
Review petition.
But what had happened, my lord, there was a land acquisition proceeding at Petkuchi, my lord, for the Indian Oil Corporation, Assam Oil Division, my lord. Now, the collector determined the compensation at 16,000 odd, my lord. Then a reference was made where the amount was enhanced. But we were not arrayed as parties in the reference. Then what happened, my lord? They came up before the in appeal under 54 before this honorable court.
Who?
The claimants, my lord, the landowner. They came up before this honorable court and this honorable court enhanced the compensation further from 50,000 to 70,000. Thereafter, we received a notice that it has been enhanced. Then we have deposited the money already, madam. We are seeking a review.
Why?
On the ground that we were not made parties, either before the reference court or before the honorable.
Is it required to make you a party?
We are a proper party, madam. There is a judgment. May not be necessary party, but we are a proper party.
Oh, then why should we review it now?
Because
To
in fact,
reopen something which is closed?
madam,
Did
we
you
have-
raise that issue before in the section 54 proceeding?
we are not made parties. We are
Not
seeking-
even in the section?
No. We are seeking review of the section 54 order.
Who is required to be made party as per section 20?
As per section 20 of the CPC.
Land acquisition.
Land acquisition. I am a party interested as per 54(2), madam.
54, we will look into it. First, come here.
The applicant, all persons interested in the objection, except such if any of them have consented without protest to receive payment of the compensation awarded, and in the objection is in regard to the area of the land or to the amount of compensation to be collected. That has been interpreted, ma'am. May I rely on that? Judgment of 1995, let me rely that at least I have an right to be heard in the reference.
Why?
The apex court says so, my lord. May I just place that judgment, my lord? 1995, 1 SCC page 221, ma'am.
What does it
Para
say?
12, ma'am.
What does it say?
It has interpreted the term party interested. In the middle portion, my lord, the consistent thread that runs through all the decisions of this court, starting from Himalayan Tiles case, is that the beneficiary, that is the local authority or company, the cooperative society registered under the relevant state law or statutory authority, is a person interested to determine just and proper compensation for the required land and is an aggrieved party. It flows from it that the beneficiary has the right to be heard by the collector or the court.
Beneficiary?
It flows from it that the beneficiary has the right to be heard by the collector or the court. If the compensation is enhanced, it is entitled to canvass its correctness by filing an appeal or defend the award of the collector. If it is not made a party, it is entitled to seek leave of the court and file the appeal against the enhanced award and
So
decree
you
of the
paid
civil
the
court.
money against that order?
My lord?
Against the award? The reference court you have paid?
Yes, we have paid. We have paid whatever is payable under the High Court's order.
Then what remains?
We may get a refund because it has got a consequences, my lord, because there are several other proceedings which have come up following this order. If this order remains,
28A. Huh?
then my lord, then something remains.
So you have not got the money? They have deposited?
We have
you,
deposited.
You don't know? Have they informed you that they have deposited? So under such circumstances, if this money has not been paid, can we now apply section 24 in view of the recent judgment? The payment has not been made by them. You have been asking, there is no stay. Isn't it? So are you not now entitled as per the 2013 amount, as per the new indoor?
Indoor development.
So you claim your compensation now on that basis? What do you? You have filed objection? Condonation application is number?
1211.
1211. How much is the delay?
800 days.
They didn't know? When did you make the payment?
We have made the payment in 2017, ma'am.
No, pursuant to the order passed by the court.
16, my lord. 2016 itself we have made. The judgment was
The order passed by this court was when?
2015. The judgment is of 25 to 2015
Of this court?
of this court, ma'am.
Okay. And when did you file the review?
we filed a review in 2017, my lord, for 23/6/2017.
2020, no, you filed and had filed the present review petition on 23/6/2017.
Yes, my lord.
Ah.
But the
Then,
declaration was
when
filed
was
later
the
on, my lord.
order passed? Wait, the order passed on 25/2/2015. And when did you make the payment?
On 22/7/2016.
22?
7/2016.
Then why did you not take a review then?
That is the dilemma. That is the delay.
Why?
Official, my lord.
So,
We have taken
on
a
that
legal
ground, you
opinion,
did
my
not-
lord. The lordship may kindly turn to para 11, my lord. Not 11, sorry. Para from 10 onwards, my lord, we have explained.
Hmm.
Page 6.
Yeah. Now, tell me another aspect. That is another aspect. Whether limitation would be there,
Initially, at least, initially,
more
we have not-
particularly in view of the 63 Supreme Court.
for review. Limitation will be there, my lord, because the Land Acquisition Act says that the EPC will be followed. So far,
Oh, this is a land acquisition appeal or not in a REIT, no? We are not in a REIT.
it is not a writ.
Okay. Oh, then we
For-
should discuss.
For writ, my lord, that division bench has been told.
Then 63 Supreme Court.
And there is a division bench of this honorable court. Also.
I'm still forgetting that I'm back to bench one. Yes. Initially, I thought that. Now you paid the money. You were given the opinion on 6/1 to the 24/2/2016. So with that opinion on that day, thereafter you should have filed.
At that time, some time was taken, my lord, for taking the approval and etc. My lord.
Does it take how much time it takes? When did you file it?
We filed in 17, my
So,
lord. A year.
Oh.
Now, the respondents will not suffer any prejudice, my lord,
why not?
because the money is already deposited.
You say that you have no objection in the payment of the money.
Well, that is up to the collector to disburse, my lord.
No.
I have already deposited.
100% the moment I start the review, everything will start.
Because my lord,
100% the prejudice will be there.
my lord sees that we have deposited. If the collector does not, but there is no stay order, my lord.
We dismiss it, then whatever the collector doesn't do, then he has recourse. Now, this is an application under Section 5 of the Limitation Act for condoning the delay of 840 days, na?
840.
840 days in preparing the review application to the judgment and decree dated 25/2/2015,
15.
passed in LA Appeal number 8/2005. It revealed that the applicant herein was neither made a party in the reference proceeding nor in the appeal proceedings. A perusal of paragraph number 8 of the incident application categorically admits that the Deputy Commissioner, Kamrup Metro, by letter dated 6/1/2016, intimated the applicant that in terms with the judgment and decree dated 25/2/2015 passed by this court in LA case number 9/1990 in LA appeal number 8/2005, an award had been prepared amounting to rupees 26,18,622, and the applicant was directed to deposit the said amount for disbursement of the same in terms with the said judgment of this court. This aspect of the matter came to the notice of the applicant on 25/2/2015. Came to the notice of the applicant only on receipt. This came to the notice of the judgment and decree passed by this court on 25/2/2015 in LA appeal number 50/2008/2005, therefore came to the notice of the applicant on the basis of the said communication dated 6/1/2016. It is further seen that the applicant thereupon sought for a legal opinion. And on 24/2/2016, an opinion was given that the applicant is required to file a review against the judgment and decree dated 25/2/2015. The applicant thereafter and also to deposit the said amount in order to avoid accrual of further interest. The said amount was deposited on 8/7/2016 by the applicant to the Deputy Commissioner, Kamrup Metro. Almost after 1 year, the review application was filed on 12/7/2017. Almost after 1 year. When was the review application filed? 23?
6/2017.
2017. Was almost after 1 year. The review application was filed on 23/6/2017. And in that process, a delay of 841 days had occasioned. The only ground which have been assigned is that it was on account of certain instructions to be taken from the higher authorities. The said review application could not be filed. The said grounds do not inspire the confidence of this court, taking into account that as far back in the month of January 2016, the applicant very well knew about the judgment and order dated 25/2/2015, judgment and decree dated 25/2/2015, when the Deputy Commissioner Kamrup Metro duly intimated the applicant. Not only that, on 24/2/2016, the applicant was also given a legal opinion to proceed with the review application. Then also, there has been the review application was not filed till 23/6/2017. Under such circumstances, as the delay, as the cause shown for the delay being not sufficient, this court accordingly rejects the instant application for condonation of delay. The consequential effect of the said application being rejected is that the review application becomes barred by limitation and as such not maintainable.
LA case number would be 7.
Same date, 25/2.
Same date, same date.
It is 5/2/7 and 25/2.
25. Same judge. Twenty-nine.
Yes, what is this?
Here in this case, the IA Victoria Lottery with the condonation of delay in preparing the appeal lottery. And this
Huh?
another case is pending between the same party lottery, which was came up before your lottery on 11th of March 2024. And your lottery has directed to read the matter along with the state IA on 22/3/2020.
What is this I business? For delay?
Delay lottery.
How much? 901 days. So, why is such a delay?
So delay, they were not made parties in the testamentary case.
You went to Japan.
One is Mumbai, 2 daughters are there, one residing in Mumbai and another with Japan.
Oh, this matter. Somehow I remember this matter. Why?
So has fixed on 22. That is another case, CRPIO.
Oh, yes. This is the matter on 22.
Yes, you're already
22?
ordered.
4.
See.
This is the matter on 22/3/2024 on with
CRPIO 307/20.
I'm coming in 5.
days, my lord.
No objection. Yeah. We impose a cost, huh?
My lord, if it was this, my lord, my name has not shown, my lord. Earlier set of council, my lord, has shown, my lord, in the court, my lord.
Whose name?
My lord,
Whose name was put?
in the earlier set of council, my lord. And I have annexed the, my lord, post list also, my lord. That's why you could not appear, my lord, in the. Yes, my lord, please. I have annexed the, my lord, post list also.
The Twitter miscase 32/2023 IHC 138/2000. Twitter, huh? IH Both the applications are taken up together for consideration. I've heard Mr. R. Sharma appearing on behalf of the applicants, and Mr. Suenso appearing on behalf of the respondent. IS Civil number 1338/2023 is an application for condoning the delay of 63 days in preparing the application under Order 41, Rule 19 of the Code for restoration of the appeal, accompanying appeal, which was dismissed for default by an order dated 23/1/2023. This court has perused the reasons, the grounds stated in the said application and is of the opinion that the same constitutes a sufficient cause for condoning the delay of 63 days. Miss case number 32 of 2023, next slide, is the application under Order 41, Rule 19 for restoration of the accompanying appeal, which was dismissed for default by the order dated 23/1/2023. The grounds assigned in the said application have been duly noted. The learned counsel for the respondent also have not objected to both the applications. Considering the above, the appeal is restored. The instant application is allowed, thereby restoring the appeal to the file of this court. Accordingly, the IA stands allowed. Both the interlocutory applications stand allowed. Next, we have a testamentary appeal. You are paying for a respondent?
My lord, I can prepare only for one. I will have to take fresh step for 2 and 3 months. Pro forma respondent, newly implemented pro forma respondent number 2 and
LCA greatly. In view of the orders passed in,
Miss case 32 of 23 and IA civil number 1338 of 23.
in view of the orders passed in Miss case number 32/2023 at IAC 1338 of 2023, the instant appeal is restored to the file. Mr. R. Sharma, the learned counsel appearing on behalf of the appellant, submits that service upon the respondent numbers 2 and 3. 2 and 3, nah?
My lord.
Is again required to be taken. Accordingly, the respondent, the appellant, is directed to take fresh steps upon the respondent numbers 2 and 3 by way of registered as well as usual, and file an affidavit and within 3 days. The registry will verify as to whether the LCR have been returned to the court below. If it has been returned, then the registry is directed to again call for the LCR.
My name may be shown in the,
The name of it's not shown today.
today it has shown.
The registry shall also show the name of Mr. R. Sharma as the counsel appearing on behalf of the appellant.
Hello.
Ivan,
Yes, you have not taken steps, usual process.
My lord, the 15 the butterfield by the 8.
Why?
But my lord,
Where?
page number 17, my lord. But it is my lord denied that no
Indicate
instruction,
that the learned counsel for the petitioner upon instruction wishes to withdraw the appeal.
no instruction was given, my lord.
So it was withdrawn.
My lord,
The only thing is review. You can't file this application for IA for restoration.
my lord, without instruction, my lord,
Huh?
there was specific
So you have to file a review. Is there any other way? This, you have to ask for a review of that order. You can't ask for restoration. This is not dismissed for default. আৰু এখন IA আছিল এই দুখন লওক দুইটা IAC 812/2020 and miss case number 20/2020. Yeah. This court, by an order dated 7/6/2019, had dismissed the instant appeal and the accompanying RSA number had dismissed the accompanying RSA number 148/2018 on withdrawal. When the appeal came up for hearing. In the same backdrop, if this court takes note of the two interlocutory applications, it is seen that the application for condonation of delay relates to condoning the delay of 13-17 days in filing the application under Order 41, Rule 19 for restoration. Filing the application under what? Mr. What type of petition is this? Filing the application under Order 9, Rule 4 for filing the application for restoration of the appeal. Mr. Ghosh, let us treat this as a review. It's same 30-30. You have filed objection against you don't want to file written objection. Mr. Ghosh, are you filing an objection to the continuation application or not? Make it simple. Are you filing or no? If you are not filing, I'll take it as an oral, and then I'll. Huh? Oral. Yes, why the delay?
Well, paragraph 7 I have mentioned, my lord. The whole lady has made out even her daughter to marry and she lived with them, my lord. During the period, my lord, from 19 to 23, she was outside. And 10, my lord. Thank you.
What has happened to the complaint against that lawyer?
Didn't set up.
Huh?
Didn't set up, I do not know.
Right? That is one. Secondly, in the execution proceedings in 2021, the applicant number 2 duly appeared.
Yes, two appeal.
Didn't he know then
Yes,
that the appeal was withdrawn?
Yes.
Yeah.
One, my lord, did not know.
Forget about one. Are you not in talking terms with your mother?
One is the, my lord, actually was building, my lord, one.
I'm not
is-
concerned with one. Are you in talking terms with your mother?
Yes.
Well-
But he was, my lord, not here. He was outside the state, my lord. And after coming to the Guwahati, my lord, he, after knowing the execution, he, my lord,
Who dismissed it? There is some limits of lying. It's absolute lie on the face of it.
my lord, actually, mother, my lord.
Mother, forget about the mother. Why are you making this statement then? Finally, see who has drafted this petition. Mr. Kare, who has drafted this petition?
Paragraph number 10, my lord.
Forget about paragraph number 12, 7,
10.
12. The applicant number 2 was also staying at Bangalore after filing of the second appeal, and during so and so he had little knowledge about the legal proceedings for which he could not acquire about the second appeal. It is only after the return of so and so they inquired. On the other hand, you categorically mentioned that you have appeared in the execution proceedings in 2021.
Yes.
Therefore, this is a case of cost to be imposed. That day I have imposed a cost on similar terms 50,000. Now this will be 85,000.
The mother.
Huh?
Mother was, my lord, contacting.
What were it?
The mother was, my lord, contacting, my lord, with the lawyer.
Mother.
The mother.
Mother was not contacted by the son. And both of you together filed this application.
My lord, regarding this, my lord, he was.
You can't make that stuff.
Where is my lord?
Where is a document, Mr. Kadis, show me a document to show that from 2019 to 2023, 2019 to 2023, you were at Bangalore.
It was not.
Huh?
It was not annex, my lord. Otherwise I have to annex the, my lord, the ticket, my lord.
Therefore,
Ticket.
this is an application file under Section 5 of the Limitation Act 1963 for condonation of delay of 1317 days in filing the application for restoration of RSA 148/2018, which was dismissed on withdrawal on 7/6/2019. This court have duly taken note of. From a perusal of the materials on record, it reveals that on 7/6/2019, the RSA number 148/2018, which was at the hearing stage, was withdrawn by the counsel representing the applicants. Full stop. It is under such circumstances the said RSA number 148/2018 was dismissed on withdrawal. Full stop. The reason assigned for filing this application on 17th of March 2023, that is after a period of 1317 days from the date of dismissal 13, 17 days, is that the appellant number 2, appellant number 1 was at Bangalore with her daughter, and the applicant number 1 was at Bangalore with her daughter, and the applicant number 2 was also staying at Bangalore after the filing of the second appeal during the period from 2019 to 2020. And that he had little knowledge about the legal proceedings, for which he did not inquire about the second appeal. It is the specific and categorical statement made in paragraph number 12 that only after return of the applicant number 1 from Bangalore in the month of January 2023, they inquired about the second appeal in the month of February 2023 from the website of the Guwahati High Court and came to know about the withdrawal of the second appeal. Full. On the other hand, a perusal of the said application, and more particularly at paragraph number 8, reveals that in title execution case number 15/2019, which was continued after the withdrawal of the second appeal, which was started. This was started after the withdrawal of the second appeal.
Yes, ma'am. Yes.
No, title execution.
No, my lord. I am only submit after me.
No, it has to be after, not. It is 15/2019. But it is why it is number 15/2019. Okay. On the other hand, at paragraph 8, a perusal of paragraph 8 of the application shows that the applicant number 1, applicant number 2 have duly appeared before the executing court on 8/2/2021 in connection with title execution case number 15/2019, which was continued pursuant to the dismissal of the RSA number 148/2018. Therefore, when the applicant number 2 had duly participated in the said title execution case number 15/2019, and that too specifically on 8/2/2021, the applicant number 2 duly had knowledge about the order passed by this court on 7/6/2019, whereby the RSA number 148/2018 was dismissed on withdrawal. Therefore, in that view of the matter, the grounds which have been made for seeking condonation of delay of 13, 17 days on the face of it appears to be misleading and mischievous in order to appears to be incorrect and mischievous in order to mislead this court, for which this court dismisses the instant application for condonation of delay. Full stop. Apart from that, this court also finds it relevant to take note of that when the regular second appeal was dismissed on withdrawal, the question of restoration of the said appeal is beyond comprehension. And as such, on merits also, the instant application merits also the accompanying application for restoration of the appeal has no legs to stand. Consequently, the interlocutory application number 812/2023 stands dismissed with cost quantified at rupees 10,000. Miscase number is, na? In view of the dismissal of the interlocutory application seeking condonation of delay and the rejection of in view of the rejection of the application for condonation of the delay, the instant application is barred by limitation and as such cannot be entertained. Apart from that, the instant application is totally does not have legs to stand in view of the RSA number 148/2018 having been withdrawn. The LCR is not here.
Article
How much delay?
28 days, 23 days.
Service not complete. Service being not complete leaves the matter after completion of service.
Hello, in this case, petition number 1 died, madam. I have filed 3 applications, madam, for delay condonation, substitution, and for setting aside abatement. There is delay of 452 days in filing the substitution application. IA number 3589.
We issue notice. Notice has to be issued. Oh, you are there. You have objection? PRP?
Yes.
All the 3 applications are taken up together for consideration. Pursuant to the filing of the revision application being revision petition, civil revision petition number 37/2015. The petitioner number 1 expired on
4/3/2022.
4/3/2022.
2022.
3/2022. Thereupon, after a period of 462 days, these 3 applications have been filed for substitution of the legal representatives. But 3 applications have been filed. IAC 3589/2023 relates to condonation of the delay of 462 days in filing the application for condonation of delay of 462 days. IA 3592/2023 relates to setting aside of the abatement insofar as the petitioner number 1, and IA 3594/2023 relates to another one. How many IAs, sir?
P590 is wrongly filed, my lord.
Huh?
P590 is
Wrongly filed. And IA 3594/2023 relates to substitution of the legal heirs of the respondent petitioner number 1. Mr. D. Kolita appears on behalf D.K. D. Kolita appears on behalf of the respondents and does not submit any objection to the said applications. Consequently, this court therefore condones the delay of 462 days in preferring the application seeking abatement of the setting aside the abatement of the petitioner number 1. According, this court also set aside the abatement insofar as the petitioner number 1 and substitutes the applicant number 1A and 1B of IAC 3594/2023 as the petitioner number 1A and 1B to the accompanying revision application. All the 3 applications accordingly stands allowed. The petitioner is directed to file an amended memo of parties before the registry of this court by 18/3/2024. The registry shall, on the basis of the amended memo of parties as well as the order passed herein, shall make necessary changes in the cause title of the accompanying revision petition, as well as shall update the same in the CIS. IAC 3590/2023, the learned counsel appearing on behalf of the applicant submits that this application has been inadvertently filed, for which the same stands, for which he submits that he would not like to press the same. Accordingly, the said interlocutory application stands closed. Main petition 2015. Taking into account that the parties are duly represented, list the matter for hearing on 2nd of April 2024.
Can it be after 4? After
Okay.
4 seconds.
We'll have it on 28/3/2024.
Publish.
This is late by 23 days, Lord. Okay.
Service complete. Notice has not been issued.
Yes. Notice has not been.
Issue notice making it returnable by 4 weeks, steps by upon the respondent by registered as well as usual.
Right.
This is the application for the condonation of delay. Yes, what is this review?
Lordship, the review of
For what?
your lordship judgment dated 18/11/23.
Yes, what mistake I have done?
No. Mistake is not on your, mistake is on our part, lordship. On
Ah.
that day, we have not apprised your lordship that Ministry of Jal Shakti is also one of the necessary parties to be included in this writ petition. Although we are not disputing the amount for which the petitioners have claimed, but as your lordship is aware, in
I know that in other cases
Yes,
I have
yes,
made
yes,
that.
yes.
Yeah, nobody said so.
Yes, lordship. This is the mistake committed on our part.
And without that, you can't get the money.
Lordship, that is because administrative approval is there. That is page 15, the last portion, that central there. We have specifically stated.
Where is the review petition of lawyer? You do one thing.
Lord.
We'll take it up some other day.
Lord.
You serve a copy of the review petition to that lawyer.
Lord.
Then we will see what to be done. How can it be done?
Because in other cases, they have filed one IA, the case which are still going on, that is in 45/26/2023,
Hmm.
pending. So they have filed an IA for implementing Ministry of Jal Shakti. But since this case is
In some cases, I have made the ministry of yes.
yes.
No, I remember that. No, therefore, the question is, you serve a copy of it,
Lord,
and then I think the best option would be we can treat this review as an IA
Lord,
and then complete Jal Shakti there
Lord.
and pass an order.
Lord.
I think is
Yes.
the better way.
Yes.
Because if I review again here, again I have to complete there.
Okay.
Isn't it?
Yes.
If we can treat this review as an IA,
Lord.
it will be better.
Lord.
Knowledge, it will have otherwise it will be a very long run process.
Lord.
And for which they may file contempt.
Yes, they have, some of them have already filed contempt, Lord.
Very good. List the matter again on 27th, 27/3/2024. In the meantime, the Mr. Toronto, the learned counsel appearing on behalf of the Water Resource Department, is directed to serve a copy of the review of the application to the counsel appearing on behalf of the petition. Tell him whenever you tell the reason why the copy has been served, then only he will be forwarding. Otherwise, he will be more happy filing a contempt. And the problem arises. Item? Yes, what are these?
My lord, may first take up IA 3077 of 23, my lord. An injunction order was passed. IA 3077 of 23.
Yes, what is this? We have
Injunction-
something here. What is it? What is it?
My lord, they have given a pen drive, I guess.
Pen drive.
Respond.
What is this?
They are taking market order. The contrary of the water, they have got the order. They are they have certain 14/12 color what they have done. If I think which already was there, they have removed that incentive.
Huh?
They have removed that incentive. And on 15/20, there was an argument between the parties that there is a status quo order which is binding upon both the parties. You ought not to have removed the incentive that existed long. Then, well, they allowed us to restore the incentive. And thereafter, they have come up certificate alleging that on 15/12 we some photographs. So I have
Who is now continuing with the business?
I'm continuing the business by.
What is this type of filing here? Why are you filing this?
My lord, but my business is hampered because my lord, I took a plot of land for parking the vehicles, my lord. Now they have put a tin fencing in between the land. Because of that, my lord, I cannot park the heavy vehicles, my lord, the buses and all. It's a transport business. So let the tin fencing be removed, my lord. That's why I filed an application. Because my lord, if my lord,
Prior to the order was not.
Why there are two RSAs?
one against the counterclaim, the landlord has filed against me, my lord.
Who is the landlord?
He is
I'm
the
the
landlord. In respect of land,
Landlord tenant?
land, my lord.
Landlord.
1955 Act. Non-agricultural.
Oh. And what are these IS for?
IA 3077 is under order 39 rule 1 and 2, my lord. IA 38 is the violation application and IA 39 is for mandatory income to remove the tin fence.
Do you file objections? IA 38 and 39.
38 and 30.
38 I have here. In the meantime, registry shall bring on record the objections so filed by the respondent. Some objections have been filed in.
Both the IA.
38 and 30.
Now you have filed in 38. 39 also you have filed.
Right.
Oh, then what remains? Where you want to file objection? In 3077. Have you filed? Oh, you want to go to jail?
So 38 is for.
If there is a violation, obviously.
There we find out. 38 is the exception violation.
Main
3077 is the injunction violation.
3077 is the order 39 1 and 12.
3077 is the application for injunction where they have paid for injunction not to dispose them from the designated.
Okay, then
In
38
that-
is
in that
38.
application, this honorable court by order to 11/10/2020 passed an order directing the party to maintain a status quo and has also directed the
Oh, you have 2A, you have filed.
My
way ahead.
status quo, my lord, which should not preclude the applicant from continuing the business of the property.
Or do any construction.
That is not there.
Page 17. Whether the lordship takes up the
Now what is this? This problem is with the team.
Tin fencing, my lord. Only with the tin fencing. Because my lord, if my lord takes up
Now
the-
who is in possession of behind the team?
behind the team we are in.
Huh?
There are
behind the
residential-
tin, they are alleging that they are in possession.
No, behind the safari car. Who is
Safari
in?
car, my lord, we are in possession, but we cannot park the vehicles.
No,
my lord.
kindly come to page 20 of IA 38.
Behind safari car also, my lord, we are in possession. But the problem is that, my lord, we cannot park the buses and all.
Huh?
We cannot park heavy vehicles like buses and trucks.
Where?
In this, my lord, if my lord takes up exhibit 3 series, my lord, of our evidence, my
No, kindly come to IA 38 of
38,
2024.
my lord.
There are few photographs. Kindly come to page 20.
My lord.
This tin is this side, your land is this side or that side?
Both sides.
Huh?
Both sides.
They put a tin in between.
In between. That is the problem.
And behind the safari car, we
Gyro.
have our residential. And there is a purpose of it is keep fencing. Like
Okay. No. Wait. Answer can be made in a very simple time. Where's the plane?
Plain, my lord, will find it. Okay. 6 to page 15.
Plane?
Page 6, my.
Huh?
Page 6.
Here. Plot of land.
Plot
A
of
plot of land measuring 4687 square feet covered by dark number 395. That's it.
Right.
46 square feet would be
divided by 1/5.
32 lesser.
32. Divided by 1/4.
32 lesser. 32 lessers will be
1/4, 12 letters.
1 kata 12 lessers. You are in possession.
I mean,
That is the suit.
that is the tenant.
So beyond that, And the teen is in between it?
in between. Beyond that, they have their houses.
Take up by
Yes.
Mera last time where they along with it, which was it covering area of apart from this, there are other
Be that as it may, the question arises when the injunction is given in respect to the suit land.
melodic I think of the IA.
No, that IA categorically says, 3077 says, says accordingly as an interim measure until the next returnable date, both parties are directed to maintain status quo in respect to the suit land, which shall not preclude the applicant from, huh?
You know, the order 7 8
Ah,
now the of their IA. It that has 7 Kara 7 of them.
IA number?
IA number 38 is 8 Kara 7. That is the
Is 8 para 7. Yes. When the petitioner was not available in a month, specifically the opposite party along with some witness who includes the so and so woman entered into the suit land and tried to forcefully put a tin fencing in the middle of the land. Thereafter, the staff. Let us see the.
now
Like, if there are any houses or any structure, permanent structure, anyways, I won't be able to park my lot. If there is vacant land, then only I will be able to park.
Yes, what is your
19 19
Hmm.
30 for the document are 14 12 15 that is prior to date of election.
Okay.
On that day, they removed the defense. These defenses were already there.
Who removed?
So the applicant.
Then again,
Then on 15/12 morning, when there was a confrontation with the parties, that status quo order on 11 days bind both the parties to maintain a status quo on what how they have removed defense. Then they have restored, they allowed us to restore the defense. We have just again the next.
and what is this 1/3/2024?
Well, this have not have for the purpose of as there was ethnic dignity training house and the tenanted premises purpose. This was put because the applicant, staff members and others, after 8 o'clock, they gather there, they have their all unsupervised activities are continued.
Hmm.
And just to protect the house from the tenant premises, this shed was constructed block. That's why it's not paragraph.
Now, whether you have made any, you are using that land for parking,
Parking.
then how do you come, will you get the benefit under section 5?
Parking, along with the parking mallet, I also have a ticket counter.
The small one,
That building mallet.
how big? How big?
It's around mallet. I have constructed it mallet. I have constructed Latin bathrooms also mallet.
When? Within 5 years?
Within 5 years. That is my contention. In 2009, they have also accepted that.
No, understood. Within 5 hours, how big?
My lord, square feet, I don't know, but it will be around my lord 500.
500 remaining you take over. You dismiss this here.
My lord,
Others, the substantial question of law arises.
in fact, both the courts have decided this.
My lord,
In against the plaintiff,
Hmm.
as that they did not construct, they could not put the construction within 5. 20, and it was their own contention that they have constructed about the land on 2009 and 2010.
And when was the lease?
2003.
My lord, if my lord is the lease agreement that they have given exhibit C, there, my lord, they have
Now, whether there was a permission to construct as per the lease agreement?
permission to, but in the lease agreement, it was not given, but we have taken.
Written?
They have accepted us in the cross exam. They have accepted.
No, no, forget about the cross agreement. Is it written?
Well, we have given a money receipt, my lord. We have paid 12 lakh rupees to them.
You constructed there with permission from the GMC?
But that permission copy we have not.
Okay, we asked the GMC to demolish the matter. They come outside the ambit of Assam urban area.
Even that concretely decided
That is why I fixed this matter for hearing long time back. And now these problems have arisen. Well, hear this matter. You don't have a point.
Let it come for hearing.
Eh?
Let it come for hearing. Let it come for hearing.
Yes, I already fixed this matter for hearing, and now, as I left this bench, now all these applications have come in. Okay. Taking into account the above, this court reiterates the order passed by this, reiterates the continuation of the order dated 11/10/2023 passed in IA Civil 3077/2023 till the disposal of the appeals. Full stop. This court, taking into account the nature of allegations which have been leveled in the interlocutory application, is of the opinion that both the appeals requires to be disposed of on an urgent basis. Taking into account the above, this court fixes both the appeals for hearing on 4th of April 2024 or after Bihu. Both of you are not contesting elections?
After.
Okay.
We are too young.
Didn't get tickets. Okay, on 23rd of April 2024.
Deeply.
We close IS 302277/2. In view of the above order, the IAC 3077/2023 stands closed. Other two remains.
Apply.
Yeah, Your Lordship. Here we have filed a petition for early hearing, Your Lordship. So we have to not raise the opposite party here, so we cannot.
Early hearing?
Yes, Your Lordship.
When do you want?
Your Lordship, after you take it here.
Where's the other? Oh, I can't take it up. Sorry. This is again, I think I appear in this matter.
Okay.
Read. No. This was my client earlier. Yes, yes, yes. Yes, fine. List this matter before any other.
Aye.
Yes, what is this? I for?
I from beginning a stay order passed by the Tamil court Milord in bill division.
Why?
It is a case of title status file. It has been decreed in my.
What is that order passed? Let us see. Execution.
Right. Case 80 Milord, 81. 80.
We do one thing. We'll take it up on next Wednesday. On Wednesday, we take it up and give you the liberty to mention for upgrading. Okay?
Fine.
Upgrading along with after the admissions. Oh, you see, this court is taking up. Once it comes up for me in admissions, it will be finished this time. So let it be on Wednesday. Not in the motion, let it be in the admission.
Well,
list the matter for admission on 23/2024. Okay. CRP order, not in the IA. Yes, what is this?
I for early hearing.
Early hearing.
So that's why you're looking
You want an early hearing? Why?
for
What is the
two
reason?
rounds of litigation, your lordship, the present appellants have failed.
Huh?
Earlier two rounds of litigation, the present appellants have failed, your lordship. Their applications were dismissed.
Hello.
However, not been able to enjoy the.
This court have duly taken note of the contents of the instant application. No. This is an application seeking early hearing of RAC number 306/2017. This court have duly heard the learned counsels appearing on behalf of the petitioner, appellant, as well as the respondents. So taking into account the above, taking into account the grounds assigned therein, it is the opinion of this court that the matter requires an early disposal. Considering the above, this court fixes this matter on 4th of April 2024. After Bihu, on 23rd of April, 23rd on 2024. And main খনত লিখি দিব list on 24th of April 2024 for hearing in the court. Yes, what document you wanted?
Lordship, the two medical documents want to reduce before the Nana family court in the divorce procedure.
Where is that order?
Page 70.
Page
70.
17.
70.
70.
Yes, sir.
So against that documents, what objection here? Who? What's CRP?
This present CRP lordship, it was already fixed on 27th. As lordship, out of this CRP pendency lordship, one mediation was held. That mediation due to that.
CRP is fixed on 27/3.
Yes, Lord. So we have filed this IA, Lord.
Okay, we'll have it on 27/3 then.
Lordship. Criminal matter, my lord, as per the note, it's not.
Criminal matter is not before me.
It is tagged there, my lord. It is tagged, it may be segregated. In fact, lordship, what happened in this case?
Criminal matter says last is list on 9/2/2024.
Dated 22.
We'll see different. First, we need to finish off this. This is an absolutely unnecessary application.
But this application during the pendency of this.
Somebody allows this application. What is wrong?
No, Lordship, my petition was rejected. Against that, I
Your petition was rejected.
Yes.
Why?
That was rejected, Lordship.
Where is that order of
Page
rejection?
70, Lordship. Peruse the materials on record. It appears that the petitioner has submitted Xerox copies of both the documents, which the petitioner wants to exhibit in this case as Exhibit J and K. As the Xerox copy of the document is not admissible in evidence, hence the petition filed by the petitioner for allowing her to exhibit the prescription and sonography report is rejected. Also, seen petition number so filed by the petitioner along with copy praying to appoint MS Sumitra Sharma and MS Jurismita Das as emitters.
Okay, now you want
to edit
photocopies.
those documents. Those
Photocopies.
No, Lordship, original is lying with the petitioner. As if it is admitted as an exhibit, Lordship, then he will exhibit it before the court.
Why didn't you produce the original?
Original was already in the file, and the petitioner also said if the order allows the court permits you to exhibit, then you use the evidence.
You have the original.
Yes, sir.
Okay. We'll allow it. Okay. This is the matter on 27/3/2024 for further consideration.
Can it be as a part matter, Lordship?
Why?
Lordship, to dispose
Not
of this
necessary.
matter, Lordship.
You don't go for partners for this type of matter. This is too small. People will laugh.
And Lordship, during pendency of this petition, Lordship, one IA was also filed by the husband. Their point was formulated by Court 7 to address this court on the
What?
petition.
Regarding IA for what?
IA, Lordship, it was mentioned that the camera proceedings should be taken on record. So, Lordship, an order was passed in IA.
Mr.
18.
No, madam, kindly.
Lordship,
I am not bothered with all these IA.
Lordship, then
If I allow that application, all IAs fall like a pack of cards. So how am I bothered with all this?
Lordship,
And
then
if
oblige,
he
sir.
wants to see very well, he has the YouTube, he can very well record out there.
Lordship,
So how does it matter? It is already
Then-
there on record.
then
He
your
can see
Lordship
for
will
money.
segregate the criminal matter.
Those ask Mr. Professor not to come up with this silly allegation thing before me.
Lordship, the criminal matter may be segregated. Right?
We'll see on that day. On 27 p.m. fixing it.
Lordship, oblige.
Yes, what is this?
Please, my lord, if your
A
lordship,
against what?
my lord, actually, if your lordship peruses the office note dated 21.
What are you challenging?
My lord, we have challenged the impugned order and judgment of the
Okay.
trial court
By the
dated
truth of
25/7/2019.
Okay. Section 6.
Yes,
You got to stay.
yes, ma'am.
Huh?
Yes, my lord.
Who is paying for the other side?
My lord, actually, that is the thing, my lord. That is the thing, my lord. As per office note dated 21/2024, my lord,
Hmm.
the process server's report has been received by the section. Notice was served upon
Process
the
server has been received stating notice was served upon the stolen late for order. Okay. I hope. Service being complete.
Yes, ma'am.
List the matter for admission on 3rd of April 2024. Interim order passed earlier shall continue till then.
Highly okay.
Yes, who wants to go where?
Yes, Lordship, respondent has filed judicial separation in Golaghat district before the district court.
Huh?
Before the district court of Golaghat.
Who?
Husband, respondent.
Judicial separation
Yes, sir.
from you.
Yes, sir.
Then
Then,
you don't want to separate yourself.
yes, sir. Even I don't want to divorce also. I have filed this petition for transfer Golaghat to Jorhat. Yes.
Why?
Yes,
Both are
Lordship.
nearby.
Another proceeding is pending before the Jorhat court, Jorhat district court. That is the restitution of conjugal right. They are appearing on that case, Lord.
You have filed a restitution.
Yes, Lord.
Restitution.
Yes.
And he wants a judicial separation.
Separate. That if
So
both
you
the
are
cases
forcing him.
forcing, Lord. It's
You are
my right.
forcing him. You are filing a restitution. He is filing. They get me a judicial separation.
I don't want to divorce, Lord. That is all.
Legal notice to whom?
For
Hello,
intimating my client.
you have filed your written statement?
No, Lord.
Okay. You can allow for you. We'll allow it. We'll allow this transfer. Let it go from asking the parties to appear on 22nd before the. You want it in Jorat?
Yes, sir. What do you need? Yes, Jorhat.
Moriani, we can have a district court
No,
for
yes,
you
yes, sir.
specifically.
In the district of Jorhat.
Then
Jorhat, Lord.
Jorat and Jorat appear before the judiciary on 22nd and file your written statement on that. File it,
Hello.
huh? Yes, what is this? Hmm.
File for transfer of divorce petition filed by the husband, my lord, in Dhemaji to Jorhat, my lord.
Why?
I am the wife, my lord.
Where was the marriage?
Marriage was solemnized in Jorhat, my lord, as per Special Marriage Act 1954, whereas the petition has been filed under Hindu Marriage Act in Dhemaji, lordship. And lord, altogether petitioner is staying in Jorhat, my lord, and they never stayed together in Dhemaji at any point of time.
They don't lie. They know this court is sitting. They transfer code. Very well. Itu আপোনাৰ itu গ্ৰাউণ্ডটো এইটো দিব হা এইটো বাকীখিনি ওপৰখিনি থাকিব. This court has also taken note of that in terms with section 19
Yes, sir.
of the Hindu Marriage Act
Yes.
1955, the jurisdiction for filing a divorce proceedings under the said act lies within the jurisdiction of the court wherein the respondent resides, or what are those three? There are three grounds. Give it to me.
My lord, marriage was solemnized.
লেখক give it to me. এই কোনোবাই দিয়কচোন এখন এই বাকী ওপৰখিনি লিখিলি. This court had also taken note of section 19 of the Hindu Marriage Act 1955, which stipulates where a petition under the said act is required to be presented. The various places, now in terms of subclause 1, Roman 1, the jurisdiction would be at the place where the marriage was solemnized, or as per subclause 2, at the place where the respondent at the time of presentation of the petition resides, or where the parties to the marriage last resided together. Taking into account that the application has been filed by the husband.
Yes, sir.
Seeking divorce.
Yes, sir.
Clauses Roman 3A and 4 of section 19 does not apply. From a perusal of the application, it has been categorically mentioned that the marriage was solemnized at Jorhat.
Yes, under Special Marriage Act.
Whatever may be.
Yes, Jorhat.
The respondent presently residing at the at Jorhat since
Since my lord, since the time of marriage.
her marriage?
Yes.
And the parties have also resided, last resided only at Jorhat.
Yes, sir.
In addition to that, this court also finds it relevant to take note of you have a source of income.
No, my lord.
The petitioner is a lady and has no source of income, no source of independent income.
As it is so in paragraph 11, lord.
On the other hand, the respondent herein is an employee of the Military Engineers Service under the Ministry of Defence, Government of India. Under such circumstances, he can go. 22nd, file your written statement.
What was that? Obliged.
In time order, make it good. Yes, what is this? Such a big transfer petition, something must be seriously wrong. What is this?
Well, some time may be granted, my lord. My senior is on leave, my lord.
Who is your senior?
H.L. Moria.
Huh?
H.L. Moria. My lord, leave note is there. In the meantime, I have filed an affidavit in reply.
Thought that because my has not been done for us.
Who has not seen? Respondent is who? Wife.
Husband. Thought
It's a son. Son or daughter?
Son.
What is your age? His age. Mother has not seen.
father has not
Father is who?
responded.
Son is with the mother.
Huh?
Son is with the mother.
But here the opposite party is who? Who is the appellant?
Well, the
Okay.
father-
Okay.
My lord, the father filed a guardianship petition before the Learned Family Court, Guwahati.
Hmm.
And that petition has been with the wife, my lord. Wife filed the petition, the instant petition, my lord, for transferring the guardianship petition to Jorhat.
You want it at Guwahati?
I want to transfer to Jorhat.
You are the wife.
Wife.
You want it at Guwahati. And where is the father reside?
Guwahati. I am staying at Jorhat, my
Wife want
You want it in Jorhat.
Jorhat.
And
we have filed. Yes, we have filed.
no, but you put your address at Guwahati also. Residing in the official quarters situated at the office of the Assistant Commissioner of Taxes. Why you are staying in the official quarter of the office of the Assistant Commissioner of Taxes?
My lord, I am the holding the post of Assistant Commissioner of Taxes, my lord.
Absolutely, this is not a case for transfer. You can very well come here. Guwahati, you always keep on coming. It's not a case. You are well to do. You can very well come participate here. Where is the judgment of the Supreme Court where it says that for wife one should not? Give it to me. You dismiss it right away.
My lord, some time may be granted, my lord.
Or what? We vacate the stay.
My lord, a reply to be filed. Affidavit, they have filed the affidavit in opposition, my lord. Reply to be filed. My senior is on leave, man. Leave note is there.
Who is your senior?
H.L. Moria. H.L. Moria.
Okay. We'll have it on Monday.
My lord, he is on leave till 31st March. Man.
We vacate the stay. This court, upon hearing the learned counsel for the party, fixes the matter again on. You are not there till when?
31st March.
On 1st of April 2024. Full stop. In the present facts of the case, this court is not inclined to extend the stay order. Yes, madam, what you are challenging?
Yes, relates to money. So, my lord, I have heard, my lord, both parties enter into a compromise, my lord, not.
If you
finalized,
have
my lord.
any compromise,
Very
go
short deadline
before
we
the civil court and do it.
It's a bank.
Why should this court have anything to do?
But
What is the order?
my lord,
What order you are
order
challenging?
is, my lord,
Order 9, Rule 7. The instant miscase arose out of Iman filed by
payment of
paying
money,
for
my lord.
setting aside the ex parte order dated Iman. A copy of the petition is
Let's have
received,
both
heard,
it.
learned counsel for Iman submitted their written statement and cost down due to her illness. For the question, the maintainability of the question on the ground that we have condonation of delay
At
in
least 1 week time
filing
may be given, my lord. I have
the
to
prayer to vacate
make
the
it sure, my lord.
and allowed on ground of illness of the what happened during the
Regarding filing of WS, my lord, ex parte order was passed.
Yeah.
That was set aside. But due to sickness could not file, my lord, WS.
Your written statement has been accepted or not?
No,
You wanted to file. Have you
Yes.
filed the written statement or not?
I wanted to file. I prepared written statement, but due to sickness could not file. But the petition was rejected, my lord, thinking the ex parte evidence of the plaintiff. I have heard, my lord, they have entered into settlement, my lord. That's a short period, my lord.
Okay.
Very short period.
Short period. 22nd. List the matter on 22/3/2024.
No, my lord,
The interim order passed earlier shall continue till then.
my lord, after 25, my lord, I have religious functions at my residence, my lord.
Huh?
Religious functions, I have to go
When?
outside. My lord, Monday, Tuesday, and Wednesday. Next.
That is on 18th, 18, 19, 20. So we are having it on 22nd. No problem. Because I am in favor of doing in your favor.
Yes, yes.
But payment of cost.
That is
That is.
that is universal.
Anyway.
What is the
Yes, what is this? Huh? What cost? This is for?
Transformer. Transformer, wife has filed a petition from Sonitpur to Hojai.
Yes, what is wrong? Why it should not be transferred? Hello? Get the air on air. We are having it on 22nd. List the matter again on 22/3/2024. Interim order passed earlier shall continue till then. The reason why, Mr. Ganguly, I am saying out here, your matter, what happened? The matter had come today. That matter you wanted early hearing. I directed that matter to be listed. That day matter, no? I told them to get it listed. Today it was listed. Yes, that matter. 48. Serial number 48 was that matter. You wanted an early hearing of some matter, no? Yes, I directed them to list it today. Isn't that item number 48? I don't know anything. What was your item number? Case number? That I asked that matter to be listed because I specifically told them the two matters. One is that matter and item 4950, which was there today. I asked them to list it. They, in fact, some other matter therefore got listed. No, we will do one thing. I can't fix it. That IA, you give the number. I'll ask them to put it on the list. Because I thought that, in fact, that matter, I asked them to get it listed today at the, but they got the listed some other. Something. Because Mr. Ganguly, here, you see, if it is to be transferred or not to be transferred is not the question out here. Only thing is this matter needs to be finished up. These matters can't remain. Transfer matters, keeping it pending out here.
My client deals with it. And because
No, if there's a mediation, go to the transfer. You see, keeping out here the matter out here and keeping it for mediation does not help. Huh? No, you do it there. Wait, no, if you are able for mutation or something, you can very well go, I can say in that order that both parties can very well apply for mediation out there in that particular. Let them go and mediate out there, whatever it is. But this court, you see, my basic idea is to keeping suits pending out here by making a stay is have created a havoc in the civil. They are not in a position. And people, you see, after a long time I'm taking up this matter, but people are losing faith in the civil jurisdiction because of this. Nobody wants, as I was taking bench 4-5, you'll see many, it is any matter for recovery, somehow they entangle the government and file recovery. The only reason, because they are losing faith. They here, if they do it, they will get the order out there and somehow they will get it under 226. But if they go out there, they will file the suit. After some time, it will be a decree after 3-4 years. Then they file an appeal. Then they go for 50%. This is the main problem that people are facing. Where is the matter pen?
Sonitpur, we are praying for.
my client is my
The mutual consent also, 13B will take 6 months. But you file that. I think either of it, both of you, either go to Hotai or whatever may be, file it out. If you want to mediate out something, go to Hotai, then it becomes easier.
All right.
Yes, what is this?
May I pick up? My lord, appeal, my lord. Substantial question is page number 2, my lord.
Huh?
My lord, during the, my lord, without considering the corona period, my lord, as per Supreme Court order, my lord, our delay application is rejected.
Mr. Counsel, where are your grounds of appeal?
My lord,
Substantial question of law. Oh,
substantial
very good.
question, my lord, page number 2.
Arises as to whether the first law was justified in rejecting the application under Section 5 of the Limitation Act for condoning the delay without.
My lord, your lordship,
We do
similar,
one thing, we admit the appeal. Where's the order?
my lord, order, my lord, page,
This one?
my lord,
Annexure 5?
page 33, my lord,
Annexure 5?
page 33.
Page 33.
My lord, page 33, my lord, the order.
The interim judgment was delivered and petition for Why this arbitration thing is bring? Article 2 and 4 of one is could be there. The main ground is not that.
It's 35 the railing. But similar, my lord, to check.
Ah,
my
this
lord,
one,
you-
yes, yes.
Yes, my lord, similar.
No, I know that.
My lord.
No, we have to do one thing,
My
Mr.
lord,
Counsel,
my lord.
the respondent has to be served,
Yes, my lord. No.
okay?
My lord, I submit, my lord.
No, don't call for a record. For the instant second appeal is admitted. On the following substantial question of law. Oh, you ditto put that same substantial question of which I formulated in the earlier
No, my
one.
lord, subsequently, I have found this order, my lord, after searching, my lord. Subsequently,
Whether the first appellate court was justified in dismissing the application under Section 5 of the Limitation Act 1963 for condoning the delay without taking into consideration the order of the Supreme Court dated 10/1/2022 passed in suo motu writ petition C number 3/2020. Question mark. This court issue notice Mr. Mr. AR appears for the respondent number 2 and accepts notice. Extra copy of the appeal memo be served upon him. The petitioner is further directed to take steps upon the respondent number 1 by way of registered as well as usual.
my lord.
You want to take dusty?
No, my lord. My lord, I submit, my lord, the address, my lord, I have wrongly put my lord address. I may be allowed to file the amendment post title before the registry, my lord, regarding respondent number 2 address. Father name is okay, my lord, just the address was wrongly I have.
No. I'll then adjourn the matter today. We'll have it on 22nd. You file a short application
Yes, my lord.
for correction.
My lord, amendment of post title page.
You just file a short application, for correction. Okay. Then it's okay. We'll have it on 22nd.
My lord.
22nd?
My lord.
Friday?
My lord.
Okay,
Monday,
this is the matter on Friday. In fact, this matter,
Yes.
I issued notice
Yes.
and got it served
Then your
to
lord.
Dusty, and within a few days, this order came.
My lord. My lord, in the IA application, respondent was appeared, my lord, but only in IA, their name not shown in the.
Who appeared?
I'll appear, my lord. In IA, my lord, appear.
You serve a copy of this appeal memo to him.
My lord.
Serve a copy of that.
That advocate.
We'll see.
Okay.
What is this?
Appeal, my lord, second appeal against the order of the real estate appellate tribunal. It has been admitted.
It has been admitted.
It has been admitted.
Then why it has come up?
It has come up for hearing, ma'am.
For hearing today? Why?
It has come by order, my lord. It has come by order, my lord. Someone must have mentioned.
Why? No, first and foremost, how an appeal has been admitted, mentioned. You mentioned it before whom? This court, how is it possible? It has come up for,
Hearing.
Is an IA for what?
I am
disposed?
for interim order.
Disposed?
Disposed.
No. This court is not going to take up this. List the matter before any other court.
Other